Oh,
not listed. There is urgency of the matter. May it be listed tomorrow, my lord?
not tomorrow.
Maximum urgency because I have been deprived from my legal right.
We will have it on Friday.
Friday.
Please, Your Lordship, I beg to mention for listing of WPC for tomorrow, Lordship, for motion.
What?
There is an urgency. Matter relates to transfer of the petitioner from one school to another, Lordship.
Okay.
So kindly this matter may be listed tomorrow,
When was the order issued?
on July
Why are you coming now?
27th. Because she took medical leave, Lordship, till 17 today. She's not well, Lordship. And also impugn transfer order pass because at the fact end of the service of the petitioner.
Okay. Yes.
My lord, I have a matter that is to be listed on Friday, my lord, the concern matter, my lord, the college, whether employee has been retired, the gratuity and other payment is on Friday, my lord. Orders,
We'll have Monday, 23rd.
that will be, if we better the Friday, my lord, because the orders matter, my lord.
For orders?
Yes, my
So Monday it can come up for orders.
lord.
Yes. Yes, really getting midday meal, my lord. School center are not getting midday meal, my lord, properly. So, my lord, the contemplation, my lord, all it was file and listed, my lord. So, might be it come on by Friday or Monday.
Monday, how many cases settled? Huh? 20 and Friday? Okay, Friday.
May please your lordship, small that I have an urgent application. I mean to say, Dorpan Portal, your lordship has fixed the date up to Friday, my lord. So may I move at 2 p.m., my lord? Only one case is there. Left out, my lord. It is not listed yesterday. Today at 2 p.m. because your lordship has already been fixed for Friday to get the admission of the student.
Have you informed Chutia?
Yeah, yes, yesterday evening I informed him.
Is he available today?
Today he'll be available.
Subject to availability of this.
Yes, my lord. Hello, bless.
Which I pray for listing of the petition on 26th of September in the admission college. The hearing the 26th.
May I please, Your Lordship? Your Lordship, I beg to mention for listing of a matter, Your Lordship. A similar matter has already listed on 20th of this month, Your Lordship. So this matter may be tagged along with that similar matter, Your Lordship.
On 20.
20th.
Oh, sorry.
Deeply obliged.
May I please, I beg to mention for listing, my lord, any date in next week, my lord.
Next week.
Next week.
25th.
Obliged.
May I please, sir? My lord, I beg to mention item number 17 with the consent of other side, my lord. Item number 17, my lord. I have to obtain consent of other side, my lord. My lord, I have filed one IA, my lord, in this case. The IA has not been listed, my lord. Therefore, the matter may kindly be listed in the next week along with the IA. IA civil number.
Give good time, please.
M is Talukdar, my lord. I am for the respondent number 9, my lord.
You've taken the consent from the
Yes,
petitioner?
my lord. Yes.
Okay, on the request made by Mr. Talukdar, let the council for the response number 9. When do you want?
My lord, next week, my lord, on 24th, my lord.
Please the matter after 1 week. Along with IA number?
IA civil filing number, my lord, 1043.
Oh, filing number is only there. It has not been registered.
Not, my lord. Not yet.
Then we list it after 1 week. Meantime, you get it.
Yes, my lord.
Only for-
Along with the IA, my lord, this
That's
serial
the-
number may be mentioned, my lord. Serial number 10430 of 24.
Along with IA filing number. So
10430 of 2020.
10430.
24.
May I plead your lordship? I beg to mention for listing one contempt matter, lordship. Next Monday, lordship. Orders matter, lordship.
25th.
Much obliged.
May I please, your lordship? Lordship, I beg to mention for listing of two contempt petitions, lordship. Lordship, matter may be listed on 25th of September.
30.
Lordship, 20.
30. many cases.
Deeply obliged, Lordship.
May I please, your lordship,
Mm.
I beg to mention for listing of a pending writ petition.
Okay,
Can it be on Friday?
oh. 30,
May it please your lordship. Lordship, I beg to mention a writ petition for admission for listing lordship next week, lordship, 25th, lordship.
no. 1st October.
First, obliged.
Lordship, it is regarding pensionary matter in education department, Lordship. My client is on death bed, Lordship. He has retired on 2019. Till today, he has not got pension in the name of disciplinary proceeding. But there is no disciplinary proceeding pending in 2008, since 2008. Lordship.
Affidavit has been filed.
Yes, Lordship. Affidavit has been filed. I have filed a reply to that.
Okay, 25th.
Lordship, it is 23rd.
Okay,
Obliged.
May I please, your lordship? My lord, I beg to mention an amended writ petition for listing on Monday, my lord.
what?
My lord, like the petitioner is facing serious hardship since 2011 for non-payment of the salary, my lord.
We'll have it on 24th.
24th. Last week.
May it please your lordship, WBC 828/24.
You want it
We'd
listed?
like to list it for admission.
Oh,
because
first of
if it's possible, next week, your lordship,
1st of October.
first of.
October.
May I do, lordship? I am saying for listing this matter, lordship, it is for motion, lordship. Motion on Friday, lordship.
When did you file it?
Lordship, it was numbered, lordship.
Hmm?
Numbered, lordship.
When did you file it?
Lordship, I have filed it, lordship, on last. The matter was last listed on 13th, lordship, as mission, but due to my physical problem, lordship, I could not appear, lordship. Therefore, no date was fixed, lordship. Only Friday, lordship.
Okay, right.
Obliged.
20 of supplementary list motion.
My lord, this case is connected to item number 2. So your lordship may take up item number 2 also. My learned friend is representing, my lord, the private respondents. My lord, this particular case 4729, it relates to, my lord, essentially provincialization, my lord. My lord, in the subject of, my lord, language in Bahadur Tari, my lord, ME school at Dhubri. My lord, what has happened? My lord, the petitioner, despite being one of the senior most teachers, my lord, there was a wrongful, my lord, adjudication of his date of joining and, my lord, his seniority. Therefore, my lord, he was deprived, my lord, of the provincialization process that was initiated, my lord, earlier. Now, my lord, what happened, my lord? At page, my lord, 26, this is the appointment letter. I'll just, my lord, briefly, my lord, state the facts. Appointment letter shows, my lord, that pursuant to a resolution of the managing committee, he was appointed, my lord, on 8/8/95. Now, this particular, my lord, appointment was confirmed, my lord, by the Director of Elementary Education pursuant to a direction of this court, my lord, at page 32. If your lordship comes to page 32, Annex R5, down below, your lordship will see the penultimate paragraph, Muhammad Sunabuddin Mola, petitioner, date of joining 8/8/95. And at the top of the order, your lordship will see the reference of the High Court's order, 633/2012. So this is, my lord, almost, my lord, confirmed from the records as well as after adjudication. Now, despite such, my lord, what had happened, the, my lord, district scrutiny committee recommended the name of the teachers, my lord, on the earlier occasion, which starts from page 46, my lord. Your lordship will find that annexure 11. Now, name of the school, my lord, is reflected at the top, Bahadur Tari ME School. And if your lordship comes to the next page, page 47, your lordship will see the second, my lord, column. These are the name of the teachers, my lord, whose name was recommended. Your lordship has found 47, my lord. Naushad Ali Sarkar, language, Abdul Jabbar Mujumdar, science, maths, Sheikh Mohammad Zakir Hussain, social studies, Anwar Hussain Sheikh, maths and science. Now, my lord, except, my lord, Mohammad Zakir Hussain, other teachers, my lord, they were provincialized. Now, Mohammad Zakir Hussain, my lord, filed a writ petition. My lord, the writ petitioner was, my lord, represented by my learned friend, my lord, who is representing the 7 and 8 herein. That is at page 49, Annexure 12. Now, in this order, this honorable court, by order dated 10/4/23 at page 51, directed the secretary, my lord, to take a call in respect of the appeal filed by the petitioner Mohammad Zakir Hussain, my lord. And thereafter, pursuant to this order, the secretary on 31/7/24 at page 54, my lord, had passed an order retaining, my lord, the name of Abdul Jabbar and one, my lord, the petitioner, Abdul Jabbar, my lord, and Mohammad Zakir Hussain, their names were, my lord, retained and they were provincialized, page 55, by this order. Now, in the meantime, what had happened, I have already shown your lordship's language teacher, Nosad Ali Sarkar. He retired on 22, my lord. And this particular, my lord, fact reflects from page 57. This is the letter by Deputy Inspector of Schools addressed to Nosad Ali Sarkar, my lord. So, Sunaullah Memorial Ami School, this is the base school, my lord. If your lordship, my lord, comes to page 49, your lordship will find the reference of the base school. Page 48, my lord.
Page
48. This is the district's committee report. At the top, my lord, your lordship will find the name of base school, Sanaullah Memorial Ami School. So the address, my lord, it is addressed to the base school. And the school presently in question is Mohammad Tari at Bahadur Tari Ami School. Now, page 57, this is the letter by the Deputy Inspector of Schools, my lord, to Nosad Ali Sarkar, who was, my lord, appointed as the language teacher. It is hereby informed that as per your service record, it is found that you will be superannuated from service on 1/11/22 due to attaining 60 years of age, so and so, so and so. So therefore, your working day in the last day of month is 30/11/22. So by this time, my lord, the teacher, my lord, against language, my lord, he had retired. And Nosad Ali, my lord, Sarkar was language teacher. It's reflected at page 47. I have already, my lord, drawn your lordship's attention. So presently, pursuant to the order of the secretary, my lord, dated, my lord, 31/7/24, there are only two teachers. One, my lord.
Let us see the secretary's order.
Yes. Secretary's order, my lord, at page 54. Honorable High Court order dated 10/4/23, which your lordship will find in the preceding page, WPC 3452/21. Also perused the report by letter so and so, the Assam Education Teachers Organization Act 2017, appeal petition submitted by Mohammad Zakir Hussain, that is the petitioner, my lord. Now, findings. In compliance of the High Court's order, a hearing was conducted by the secretary with the petitioner and respondents, where all submissions made by the petitioner and available records were scrutinized. DEE report and documents submitted by the petitioner and the other office records reveal that as per enrollment data, 3 teachers of Bahadur Tari Ami School are eligible for provincialization, 1 for language, 1 for science, maths, and 1 for social studies. Records reveal that DSC Dhubri had recommended the name of the petitioner Sheikh Mohammad Zakir Hussain for provincialization of service as social science tutor. So Zakir Hussain was social science tutor. Records reveal that DEO Dhubri had recommended 2 science teachers against Bahadur Tari Ami School for provincialization of services, namely Abdul Jabbar Majumdar, who joined on 93, and Anwar Hussain Sheikh, who joined later on 15/2008. Records reveal that SLC in their minutes dated 35/23 had recommended cancellation of provincialization of Anwar Hussain Sheikh as maths and science tutor of Bahadur Tari Ami School and recommended for provincialization of petitioner Sheikh Mohammad Zakir Hussain as social science tutor of Bahadur Tari Ami School. In view of the above facts, circumstances, the name of the petitioner Sheikh Mohammad Zakir Hussain was recommended for provincialization of service as social science tutor of Bahadur Tari Ami School by both Dhubri, DSC Dhubri as well as SLC DE to take needful steps in this regard. So Sheikh Mohammad Zakir Hussain was the petitioner. His name, my lord, is now provincialization against, my lord, social science teacher. As only 1 science and maths tutor can be provincialized, the provincialization of service of Anwar Hussain Sheikh as science and maths tutor of Bahadur Tari is hereby cancelled. So Anwar Hussain is cancelled, and at the top it finds, my lord, that Mohammad Jabbar Majumdar, Abdul Jabbar Majumdar, who is also a science teacher, my lord, his name has been provincialized. So there are now science and maths teacher and social studies teacher. And I have already drawn your lordship's attention that the, my lord, language teacher has already retired, my lord. There is a vacancy. Now your lordship is aware, in terms of the 2017 Act, my lord, 3 teachers, my lord, from 3 subjects are required to be provincialized. That I am not required to, my lord, draw your lordship's attention. Section 3, subsection 1, clause 11. My lord, language, science and maths and social studies. So in view of the vacancy, my lord, I am asking for a, my lord, innocuous order that your lordship will direct the district scrutiny committee to examine the matter. And my lord, if they find, my lord, that I am liable to be recommended, my name may be recommended.
Has your name been sent up?
My name has not been sent, my lord. What has happened? Now I'm coming to the next case, my lord. This is the reason for what, because my name has not been sent. Because from 2005 onwards, my lord, page 59, Annex 16 series, my lord.
Which one? Which writ
A
petition?
new writ petition, my lord. My name appears in the Dias Code, my lord. From 2006, 2005 onwards. Your lordship will see, my lord, Sonabuddin Mullah. Last name, serial number 5. Then there are, my lord, Dias Codes up to 2015-16. In each and every one, except 15-16, my lord, my name appears everywhere. And what happened, my lord? The earlier writ petition, the other writ petition, my lord, that was disposed of. Now, having found, my lord, that the order, my lord, disposing the writ petition is error apparent on the face of the record, I filed a review application before your lordship. Now, lordship having found that the order, my lord, suffers from, my lord, error apparent on the face of the record, your lordship had, my lord, in fact, allowed the review application, which your lordship will find at page 42. I take your lordships to the operative part at page 45. It starts from page 42. This is a review petition 65/17. And the order is 22/8/23. Now the operative part is at page 45. Lordship has got it, my lord. On consideration of the materials available on record, particularly the order dated 21 June 2012, issued by the Director of Elementary Education, Assam, whereby the petitioner was held to be senior to the present opposite party 7, this court is of the considered opinion that an error apparent on the face of the record has occurred while passing the order dated 28/5/14, passed in WPC 4773/12. In that view of the matter, the order dated 28/5/14, this is the consequential order, my lord. Oh, sorry, my lord, the order passed by the High Court, 28/5/14, passed in WPC so-and-so is hereby recalled. So after, my lord, this order was passed, recalling the earlier order, my lord, this present writ petition has been restored to file. Now, I also challenge the consequential order in the review application, but your lordship was of the view that since it's a consequential order, it has to be challenged independently in a separate writ petition. So the consequential order is also part of this, my lord, challenge in the present writ petition, my lord.
Where is that order?
Yes, that order, your lordship will find at page, my lord, 40. This is the order dated 11/8/14. Now, your lordship will find the reference of the High Court's order at the top of, my lord, this letter. Peruse the Honorable High Court's order dated 28/5/14, which has been recalled by your lordships in the review application, passed in WPC 4773/2012. Now, by this order, what had happened, my date of joining and seniority, my lord, was determined, my lord, adversely to me. But already there was a determination by the district elementary, my lord, Director of Elementary Education, my lord, at page 32, which I have already drawn your lordship's attention. Annexure 5. So this is, my lord, dated 21/6/2012. Now, my submission was before your lordship that there is already an adjudication pursuant to a High Court's direction. And my seniority, my date of joining has already been confirmed by this order. So subsequent order, which has been passed by, my lord, by a subordinate officer, cannot sustain. And in fact, my lord, the entire writ petition was structured in a different premise. My lord, prayer was totally different. But by that order, my lord, there was a further direction for a redetermination. So therefore, your lordship had accepted that the order suffered from, my lord, error on the face of it, and thereby your lordship had recalled it. So my respectful submission is, when the order of this honorable court does not sustain, the consequential order has no legs to stand, my lord. Now that consequential order has become, my lord, null and void. And that, my lord, order is also required to be set aside in view of the fact that that will come, my lord, in the consideration of my lord, provincialization. So, my lord, at this stage, my respectful submission is, even if your lordship does not interfere with that order of the district elementary education officer, lordship may, my lord, observe that while considering my case for provincialization, my lord, it will be governed by the order at page 32 passed by the director. That much, my lord.
Yeah, Furkan.
In the motion matter, Your Lordship, I'd like to suggest that, my lord, since he has said that the post, since the language teacher has retired, you know, that post basically gets abolished once he retires, my lord, since he was already provincialized. Had it not been, my lord, so since he was provincialized, already the post is abolished, my lord. So new advertisement will be taking place and due process will come in forth. So in that case, my lord, that part, my lord, will not, that part, my lord, he cannot claim, my lord, provincialization just because he's a thing. And my lord, if your lordship sees the, format, district scrutiny committee format, which is given, my lord, his name is basically in the list of people who are not eligible. Just show you, my lord.
Yes, at page 47, page 47.
Page 47, my lord. Lordship, his name is Sonabuddin Mullah.
Yes, yes.
Which is, Your Lordship, details of teachers, tutors who are not eligible for provincialization due to non-availability of requirement enrollment. My lord, his name is there in the not eligible category.
Then you take instructions and
I'll get my instruction, my lord, and whether we can basically, my
we
lord,
can, after
cater-
that, we
cater
can
to his
dispose
needs.
of this matter.
Yes.
Take a short time.
If there is a need, my lord, we'll see.
I'll respond to my lord, my learned friend. My learned friend is technically correct, but your lordship will consider that this is a case where there is a continuous litigation is going on. Now that writ petition is of 2012, that is pending. And lease pendants, my lord, the doctrine of lease pendants will come in, my lord. Because I was arbitrarily, my lord, rejected. My case was arbitrarily rejected.
Okay. But Mr. SK, look at the council. Do you want notice to go? Or you want to take instructions?
I'll get my instructions first, sir.
He will get the instructions.
Mr. Furkan, standing council and litigation. Is allowed how much time?
Lordship, 2 weeks, my lord.
He can take within 1 week, my
Lord,
lord.
it's a Dhubri matter, my lord.
Now it is.
Please, after 2 weeks, along with the.
Yes, both the cases. both
Along
the
with WBC.
Other matter is listed today.
Yes,
Yeah,
both the
along with WBC 4773 of 2003.
My lord, in the other case, my learned friend is representing 7 and 8. So he may appear, your lordship may record it. For 7 and 8, my learned friend will appear.
Other petition, heard SK Talukdar. Then the council. You are the petitioner.
Yeah, I am the petitioner in both the cases. What I'm trying to say, my lord, in this motion case, my learned friend can represent 7 and 8 also, because in the other case, he is representing them.
Also heard. Is there? R Islam, the net council for the response number
7 and 8, my lord.
in this.
Yes, new case, my lord.
No, in the whole case.
All case also 7 and 8, my lord.
Please this matter along with WBC number 4729. Are you entering appearance? Here's a new writ petition. I don't know whether he has the authority to appear.
My lord, in fact, they are same, my lord, same persons, my lord.
Maybe.
My lord.
But then they may like to
Yes,
get
yes,
some.
correct. I leave it to your lordship, my lord.
So that's why I'm saying whether notice should
Yes,
go or not.
my lord, first let him obtain the instruction, my lord.
Okay.
My lord will only fix a date, my lord.
2 weeks is what? Days what? 3rd October.
Obliged, my lord.
1 of daily leave, admission.
3rd October.
May it please your lordship. Lordship, here in this case, lordship, the records are with Mr. S. Priya, lordship, but due to some personal difficulty, he is not here today, lordship. Can this matter be taken up tomorrow or any day, lordship?
Tuesday, lordship, on a hearing day, lordship. Next Tuesday, 24th of September.
But Mr.
8 acre, lordship. 8 acre, lordship.
You are appearing here?
Yes, lordship.
8 acre land council. On request made on behalf of S. Buyan. Then it's standing council, higher education.
Yes, lordship.
This the matter again on 24th.
24th, lordship. Yeah, lordship, we may be allowed to go to the records because they have received record. Lordship.
On that.
Obliged.
3.
Lordship, this is a pass over time in my lord.
What?
My senior is on like in.
Up to 3.
4.
May it please your lordship. The issue revolves on one point, your lordship, whether the petitioner was served with the termination order or not. That was the precise query put forth by your lordship. And the education department has filed an affidavit to that extent. They have brought a lot of things, but they have admitted one thing, that no termination order was served on us. If I may take your lordship to that affidavit, your lordship.
Lordship, I'm appearing on behalf of Mr. B. Kaushik. Lordship, an additional affidavit was supposed to be filed, and according that has been filed, Lordship. So therefore, my lord, matter may come up in the next week. Today, my lord, some.
No, your lordship, they filed the affidavit. I have no objection. I am ready for the hearing.
No. When was the additional affidavit filed?
It was filed on 10/9/2024, your lordship.
It can come up in the next week, Lord. Today, some personal difficulty on the part of Mr. Kaushik, my lord. He's just informed me, my lord. So, since the affidavit is filed, my lord, any day, my lord, any other day.
But Mr. R. Sinha, legal counsel, on request made on behalf of Mr. B. Kaushik. Then standing counsel, when do you want?
My lord, next week when I convenience to my
26th?
Okay. Deeply obliged. Huh? Your lordship, can it be on 24th? 24th, can it be on 24th?
24th.
Deeply obliged.
24th.
My lord, in this case, we have filed the affidavit, my lord.
You have the respondent number?
I'm for the principal, my lord, respondent number 7.
Yeah, the affidavit is there.
My lord, in this case, Accountant General Judgment Party here for number 6. The principal is coming under inspector of schools. Inspector of schools, jurisdiction of inspector. We do not have role to play in regard of that. Second point is there. GPF part we have already been paid. I only do one maybe. This time GPF already I have given. Remaining pension part we do not have role.
We are in a position, my lord, what happened, his appointment order as principal has been set aside by the division bench. And his substantive post therefore is postgraduate teacher. And the post, he has drawn the salary of the principal and retirement after retirement provisional pension as principal. That is the technical problem has come. We have no issue, my lord, to release his pension with regard to his substantive post as subject teacher. And he has to recover around 6 to 7 lakhs because he has obtained the salary and pension also, provisional pension also. That has to be recovered because his promotion itself has become null and void.
That is his part.
My lord,
My part is
Yeah.
my part.
That is why we have filed the affidavit. That is why we have no enmity with him that to release his pension. But the question is that in which, my lord, the fixation has to be done. In which post fixation has to be done. So as per the existing position, he has not preferred any appeal and review against the order of his termination, cancellation of the appointment. And therefore his substantive post is subject teacher.
Well, the order of the division bench.
my lord, my contention was never about the post of principal that we have already abide by. And now we are just asking for the pension on the basis of the postgraduate teacher. And that has been reflected in the first order of this honorable court, my lord.
What is the division bench order?
Division bench, my lord, they have enacted the writ petition.
11/12/2019.
Yes.
Page.
No, equally good with the
Page 35.
On the page.
Starts from 36.
What? Page.
the 10 page will not, it is not eligible, but the second part is here. The fourth one is there. Can be it, but second thing.
Yeah, that you have already paid the GPF.
Yes, I don't have loan only this time.
That will consider. Yes, you proceed with your case.
Yes, my lord. My lord, the first contention of the petitioner is that we are not asking for the pension according to the post of principal, my lord. Already the honorable division bench has passed the order and the writ appeal was dismissed, which was filed by us. So we are not at that point at all. We are on the point, we need the pension as per the post of subject teacher, my lord. But then when they have now respondent number 7, they have also stopped our provisional pension as well.
Because
Which
that
we have been getting
1
from
minute, Professor, let us.
from last 3 months. He hasn't paid us any provisional pension, and now there is this contention from the respondent number 7 that if we give an undertaking that we are at para number 4, my lord, of their affidavit in opposition at page number 59.
No, first place your case.
Yes, my lord. Now, my lord, we are asking for the pension and the other ancillary benefits as per the post of subject teacher at this school, my lord. Now, my lord, all the formalities have been completed. Now, as per them, the only distinction they have that they should pay according to the post of principal or according to the post of subject teacher. But my lord, that has already been decided by the honorable division bench. Already it has been dismissed, my lord. So we are not on that point at all.
Let us read it.
At page number 41, my lord. Para 18. The honorable division bench
Page 31, my lord. His service was regularized by the college authority. Page 31. By virtue of the resolution number 3 of the governing body passed on 2012-2005, my lord, his service was regularized. Debaka Sharma is item number 8, my lord, with effect from 4/11/2023. So his service, my lord, past service was also regularized from the date of his initial appointment as contributor teacher, my lord, on 4/11/2023. But this is crucial date, my lord. Yes. Then, my in the meantime, whatever, my lord, the college was upgraded to a deemed university. The Hoja College was upgraded to a deemed university. He continues in the college as commerce lecturer of commerce, my lord. And in 2017, the Assam Legislative Assembly passed an act, my lord. There is called Rabindranath Tagore University Act 2017.
When was the upgradation made?
My lord.
When was the upgradation done?
Or, my lord, there is from 30th of October 2017. I'm giving the actual copy there. I'm giving the copy of that. नहीं ये तो नहीं इतना ही है टेक्स्ट कैसे just a minute, madam. There is a copy for the lawsuits. पैसा ये तो खाली बेयर एक्ट है पूरा असर है पूरा नहीं पिन मार दो
It is also annexed, melody is the another iteration melody which is disposed instructors melody is 6241/2023 melody is 2032 melody.
is the next there also, madam, but they taking all this show. I think there is not the full act, my lord. There is only some extra paper in it. So you also kindly have to come to even pages that so
Not 58 melody, existing t-shirts and stuff. 50 and the gazette was melody.
No, there is only 3 pages. Page 32. Well, may I give it full act? But I have marked my lord, so I will accept full act. Only it will put on another. Expect of the relevant PPA. Now, in that act, my lord, the act I have given, you will also kindly first come to page section 20, my lord. Whatever thereafter, let me just explain one more thing, my lord. After the university, this college of upgrade to university, the petitioner ought to have been brought in the same post or in the equivalent post. As well, section 58. I am coming to that. But he was given the temporary appointment of 45 days, my lord. Yes, assistant finance officer. There is no post of assistant finance officer. You will also kindly come to directly section 20 of that act, my lord. Yes. Section 20. The legislature has not created any post of assistant finance officer. It is the finance officer under section 20. So he ought to have been appointed as finance officer, but he was appointed illegally by the university as assistant finance officer. But he was forced to take up because he was an unemployed man. So there is a drowning man catches the straw. And he continued as such. Now, you will also kindly come to section 58. What ought to have been his position, my lord?
Section?
Section 58 of the Act.
47,9.
Yes.
Yes. 58(1), all posts of Hojai College, including the vacant posts, are transferred immediately to the Rabindranath Tagore University with effect from the date of commencement of this act. That is, this act came into being, my lord, on 30th of October 2017, as gazetted in the Assam Gazette. So all posts as they are, without any.
When was it?
Yes. Date is 30th of October 2017, the commencement of the act, published in the Assam Gazette.
Okay.
Now, this section says, my lord, all posts of Hojai College, including the vacant posts, are transferred immediately to the Rabindranath Tagore University with effect from the date of commencement of the act. Subsequent to is important, my lord. For me, the existing teachers and staff of the Hojai College shall constitute a special cadre with respect to their service condition at the time of their appointment. So, by virtue of their, my lord, I would be included in the special cadre of the university because I was already serving in the Hojai College in a regular post. They didn't do it. What they did? Out of the range, my lord, out of the periphery of the post to be that is prescribed under the act, they appointed me that too for 45 days in assistant my lord, finance.
Where's that order?
Yes, that I am coming on.
It's 32, my lord.
32.
32.
Annex of 7, my lord. There was sort of exploitation subject to approval by the Executive Council, Rabindranath Tagore University. Sri Divakar Sharma is hereby appointed to the post of Assistant Finance and Accounts Officer on ad hoc basis for a period of 45 days from the date of joining. This is permanent post, my lord. And there can be an ad hoc appointment in a permanent post. And section 58 ought to have been complied and separate special cadre ought to have been formed. And that continue, my lord, unabated. Next page also same. Then third page also same. Up to 35 same. It was 20. Then they started issuing advertisement, my lord, for the post. Prescribe higher qualification. I challenged that twice. And once I challenged, they would withdraw the advertisement. And and one of the challenge was in item number 6, my lord, which says we can infocus. That advertisement was also withdrawn. Then lastly, they give the advertisement, my lord, at page 45, my lord. This is the last advertisement they have issued. Page 45, Annex 16, my lord, dated.
Reducing the qualification.
Yes. Reducing the qualification, just to adjust, I have made the allegation also to fit a man from West Bengal belonging to a resident of West Bengal who was favorite of the Vice Chancellor. Now he is retired, my lord. That stage is gone.
There is no such statement, my lord. There is
Whatever,
no
whatever.
such yes, my lord.
Don't disturb us.
So, my lord, that VC is retired now. I think there will be some fairness now. New VC has come.
Where's the advertisement? Fresh advertisement.
The page 45, my lord. That is under challenge.
In this petition.
Yes.
What's the quality? What's the quality?
What happened to that other advertisement of
They would done.
2023?
They would done.
That advertisement is withdrawn.
This is the last one. How was the beta petition used? How was the beta petition? There are two more petitions earlier, my lord, challenging those advertisements. And after the representation file, my lord, they would withdraw and again, those representation become infectious. One being the item number 6.
Then what happened?
Now, my lord, now, my lord, this is our challenge. My plea is simply under based on section 420 and section 58 of the Act. Since I am the man of finance, my lord, I ought to have been given the post of finance officer. According to my qualification, I was the teacher since 2003. In 2019, I had completed 16 years of service.
There's no post of assistant finance officer.
No, it also be seen in section 20. So, your lordship may do one thing, my lord, to cut the matter short. Instead of lordship going into the whole hog, your lordship can direct the university to consider my case in the light of section 20 and 58 and this is the matter. Maybe my friend doesn't have the objection. He might have had
My lord, it's completely wrong supposition made my senior man. My lord, what happened, my lord, he was initially appointed, my lord, the contractual, my lord, for 45 days, my lord. Thereafter, it was extended, my lord. At that contractual, my lord, the appointment of the lecturer was, my lord, regularized. This for payment of the salaries, my lord.
Where is the regularization order?
My senior friend, pointed out, my lord.
Page 31, my lord, of my represent Annexure 6.
That it is mentioned, my lord, is pursuant to the page 31, Annexure 6. Pursuant to the governing body resolution number 3, dated 28/12/2015, and resolution on number 2 of 26/4/2007, the appointment of following lecturer has been.
That was in the Ojai College.
Yes, my lord.
So after it was upgraded.
Yes, my lord.
Yes.
No, by the Act.
Yes.
Yes, my lord.
There's some provision in the Act which you are supposed to follow.
Yes.
Yes, my lord. We have followed, my lord. Those who are, my lord, already, my lord, in regular post, my lord. Those are appointment regular on the basis of the permanent sanction post, my lord. They were upgraded when it was upgraded to university. As per section 58, my lord, all existing staff and teachers of college shall constitute a special cadre in respect. Here upgraded, my lord. Those who are regularly appointed, my lord. Here he is not regularly appointed, my lord.
What is it?
For humanitarian,
He was only a regular employee of Ojai College.
No, my lord, he is contractual, my lord. There's difference between contractual. My lord, he was appointed contractual against the contractual.
Come to page 31.
Yes, my lord. Yes, 31, there's resolution.
It is a contractual appointment.
Yes, my lord.
This is a contractual appointment.
Yes, my lord. Yes, my lord.
Read the language.
Yes, my lord. After this, before that, the your lordship may turn page 27, my lord. Resolution 2, number 2. It was already read. It is resolved the appointment of following contractual lecturer be approved.
This is approval.
Approve this the contractual when there is a advertisement, my lord. Thereafter, my lord, the selection made, my lord. It was the appointment of the said contractual appointment approved, my lord. And thereafter, this salary part for them, it was regularized, my lord. They are not against the permanent post, my lord. So, my lord, so thereafter, when
how do you say that?
That is the fact, my lord. We may produce the record also, my lord. There is initially there is the advertisement, my lord. Lordship may clear the advertisement, my lord.
Page 45.
No, no, my lord. Page 24, my lord. The application invited from the candidate having the latest UGC so and so, so and so, so and so. The services is purely temporary and may be terminated without any prior notice. It's completely, my lord, is not against the sanction post, my lord. So, my lord, when college was upgraded to university, they are not cadre post, my lord, it was not upgraded, my lord. And thereafter, my lord, on humanitary ground, my lord, the annexer 7, page 32, my lord. My lord, this only for humanitary ground, my lord, this the Executive Council, University, Deepak Sharma is hereby appointed as to the post of Assistant Finance and Accounts Officer on ad hoc basis for 45 days. My lord, if suppose he is, my lord, this is the regular employee, my lord. 2019, my lord, 17, 12, 2019, this appointment was made, my lord. University at the ad hoc basis. Whether is his right was curtailed or not, my lord, then why not challenge this? Because of that, he was appointed contractual, my lord. So the petitioner has no right challenge, my lord, because his post is not permanent, my lord.
What the petitioner is saying
Yes, my lord, petitioner says.
is that he was regularized by the order of 18/5/2007.
Regularized only the my lord.
And when the when the Hojai College was upgraded to the Rabindranath Tagore University, the section 20 provides that there is a post of finance officer. All right. Section 58, I think, section 58 provides that the services of the
yes, ma'am. Yes,
will form a special category.
Yes, my lord.
Correct.
Well, first, my lord, his appointment should be in cadre post, my lord. And according to he should get the regular salary, my lord, on the basis of the UGC, my lord. If it is there, my lord, let them produce, my lord. If his appointment is regular, my lord.
Those were the things cannot come, my lord, because he was already after 10 years of his regularization in the Hoja College, university came into being.
Phase 24 is very much clear, my lord.
Whatever the section 58 does not difference, my lord, whether one is ad hoc, temporary or regular. And clock is just
no, my lord. No, my lord. This
If
is my
he is
lord.
interpreting it different way, different thing.
After it is 58 is there, my lord. The existing teacher and staff of the Hojai College shall consider special cadre.
Yes.
They are a special cadre with effect with respect to their service condition at the time of their appointment. This appointment is the appointment, not contractual appointment, regular appointment. So now they are not even then everything is supposed the court they are right, my lord. This post of finance officer.
Maybe one thing is this. There's no doubt that the petitioner was appointed on a contractual basis. All right. On the basis of the advertisement.
Yes, ma'am.
Then the governing body give its approval.
For appointment, contractual appointment, it was approval on the contractual appointment.
That word is not used.
Yes, ma'am, it is there.
That word is not used.
It is there, my lord. Lordship may page 30 also, my lord. Page 30 also, my lord.
Yes.
Page 30 says, speaks, my lord, these be it resolved that the appointment of the following contractual lecturer be approved.
Okay.
Contractual, my lord. Everything is contractual, my lord. And my lord, so far, my lord, this is the annex 1 documents in additional rejoinder also, my lord. His part is contractual, my lord. So contractual appointment. So those who are appointed contractual, my lord, if you give they were, my lord, only consider on humanitarian when it was upgraded university, my lord.
No, fine. He was appointed on contractual basis.
Yes,
and the approval was given for the contractual appointment.
Yes.
What about Annexure 6?
In Annexure 6, my lord, the resolution is mentioned, my lord. The persons of the meeting so-and-so, and so-and-so, the appointment of following teacher has been regularized from the date of their joining and service. Yes. It is only for the salary part, my lord. The governing body, my lord, is only the paid salary, my lord.
In my service.
So, salary, my lord. The appointment is purely temporary on the basis of terminable without any prior notice, my lord. My lord, when there is a regular appointment, my lord,
So you are saying this regularization was not done against the sanction post?
Yes, my lord.
How do you show it?
Huh? Last line, my lord. In regular appointment, there's two approval is required. One, prior approval from the Director of Higher Education, my lord, and formal approval from the Director of Higher Education, my lord. The only governing body duty is, my lord, to putting an advertisement, my lord, and the selection was made, and therefore the proposal was sent to the Director of Higher Education, and government approved, my lord. Their approval prior approval is given, my lord. Thereafter appointment, thereafter formal appointment. These are different. If they are appointed when it's regular, my lord, it is the
okay. Here there are nine teachers, nine employees of the Hojai.
Yes, my lord.
Correct.
Yes, my lord. All are,
What about the others?
all are contractual, my lord.
They are continuing university.
No, my lord.
How were the, how did you, how were the, services, appointed in the Rabindranath Tagore University?
They are not appointed, my lord.
They have not been
They
appointed,
are not appointed.
except the petitioner.
They are not appointed, my lord, as a lecturer at university, my lord. So far, university is concerned, my lord, as per this act, my lord, they are not appointed university, my lord. Same status as well as the petition, my lord.
So you took them into your university in the same status, correct?
My lord, so far now, at present, what they are doing, I have no instruction, my lord. I have to take.
But let him go through the, I will start, cut me start. Let him go through the bill properly. Page 42. All are continuing. What is saying?
Page 42, my lord, page 42, my lord, what is this, my lord? Page
They are
42 is on.
all the
Page
individual.
42 is, my lord, they directed the vice chancellor university following appointed as a part-time employee. They shift for a period below, my lord. The Mohesh Sharma, PS controller, Tanmoy Datta, PS to register, Rakhal Chaudhary, PS vice chancellor, Samal Roy, junior assistant, Shipra Datta, junior so-and-so, Harendra laboratory, Joydeep, so-and-so, so-and-so, so-and-so. These are only, my lord, third grade and fourth grade, my lord. Daily basis, my lord. And he
What
on,
about this?
yes, my lord.
Mathematics, education, Hindi, zoology,
Yes, but
mathematics.
these are the, I have to take instruction page 31 minutes. Here also another thing was
You file your affidavit.
I have already filed my, I have already filed. The question was that, my lord, is whether the advertisement which was impugned by my learned friend, my lord, petitioner, my lord. Here only, my lord, we have given the, earlier it was, my lord, education qualification given master degree, my lord. And my lord, there's experience, my lord, experience was there given, my lord. Only that which was withdrawn by the university was that, my lord. The age was, my lord, as per some government, my lord, government some age there is division, my lord, which are not attracted with the university. That was because of that it was withdrawn, my lord. And this, therefore, we this advertisement made, my lord, as per the Bhattacharya University, my lord, the state university. The minimum qualification of the finance officer is, my lord, this graduate, my lord, and thereafter, my lord, this 5 years experience, my lord. And my lord, so far the one annexed by my learned senior friend, my client, my lord, the was 49, my lord. This is regarding the Assam University.
Central government university.
Yes, my lord. Here, my lord, finance officer, my lord, this the qualification you'll also may be read, my lord.
Master degree, yes.
My lord, is I am reading education qualification master degree with at least 55 of a marks and equivalent is equivalent grade in a point scale whenever grading system is followed to at least 15 years experience as assistant professor in the academic level 11. Level 11 means, my lord, this, my lord, those who are after appointment as a assistant professor, my lord, those who has 6 years, my lord, they're serving, my lord, are 4 years plus PhD. They are 11 level, my lord. 6 years as a regular assistant professor, my lord, level 11, my lord. And my lord, and above.
You're reading from?
Page 49. Last page, my lord.
There is my Central University Act, not a Central University Act.
This has no like a locus standi at all, my lord.
Yes.
Finance officer, my lord. Detailed eligibility criteria, instruction and guidelines, my lord. Finance officer. Preferably below 57 years. Education qualification a master degree with at least 55 marks or an equivalent grade in point scale. Whenever grading system is followed, to at least 15 years experience as assistant professor in academic level 11 and above, including as a assistant professor along with experience in education and educational administration or comparable experience in research establishment and other institution of higher education. 15 or 15 years administrative experience of 8 years shall be as a deputy registrar or an equivalent post. These are the educational qualifications.
Mr. Mehdi, I want your submission on annexure 6.
Annexure 6, my lord, their my lord is, they only, so far,
What about the others?
that is, right now, I have,
That's what
I have to take inspection.
at least the petition has to be put at par with the other other lectures.
Yes, my lord, that is, my lord, but, yes, my lord, I'll take instruction, but so far, my lord, this annexure, thereafter, he was appointed, my lord. Page 35.
That that is what the petitioner is saying.
Well,
That is
that
against
is not their claim, my lord. You lordship may come to their prayer, my lord. Come to their prayer, my lord. If that is their prayer, it was case will be different, my lord. Page 18, my lord. Sorcery shall not be issued setting aside and causing the impugn re-advertisement dated. Re-advertisement regarding the qualification and the experience, my lord. B, my lord, as to why writ of manner shall not be issued to the respondent, directing the respondent 3 to issue fresh advertisement. So far, finance officer is concerned by upgrading the education qualification as postgraduate and experience of 2 years or experience as lecturer and assistant professor 15 years. These are the prayer, my lord. As an appropriate direction shall not be issued upon the upon cause or causes being shown, if any, or upon hearing the parties. Your lordship may please to make rule absolute. These are the only setting aside the advertisements of the finance officer. They are not under this. We are appointed, my lord, or regularized, my lord. Subsequently, university upgraded, my lord.
That is not
we
the
are
case.
deprived, and that is not their case.
Because my lord,
So
my lord,
you come with the instructions on annexure 6.
Yes. Even then, my lord, because their prayer is different, my lord. Their prayer is the other person was appointed. We are not upgraded or post regularly. That is not case.
that is not the case, because
let them file separate representation.
why?
Because the prayer it is
We
prayer
know
only
the prayer.
prayers only to set us the advertisement.
My lord,
If suppose
Okay, heard Mr. R.B. Shabal, the senior counsel, assisted by Mr. Arda, the counsel.
you cannot go to
Mr.
this stage of
Mr.
college.
Mehdi, learned counsel.
You can talk only
Standing
after
counsel.
submitting.
Standing counsel.
No, only counsel.
Learned counsel, appealing for the respondents.
University, respond university.
For the responding university shall receive instructions. Well, how much time you require?
Not well, today also I'll take instruction. What happened the other person?
Okay.
At 2, my lord.
My lord, the other person may not be necessary because he cannot talk about the situation in your college. He can talk only after 2017, after the university committee.
On 24th.
24, no, instead of 24, my 20. 25.
25 is a
26, my lord.
26.
One can infectious, my lord.
Yeah, that has been discussed. This item.
8, no?
8.
Yes.
Yes.
That matter, my lord, that the records were missing for the authority department, they filed an FIR. Till today, it could not be traced out. So last time your lordship desired that without records, it may be hard, my lord. Now, actually, what we find, my lord, actually, record is very much necessary. Our whole case is, my lord, the respondent was 7, filed the documents after the interview. My lord. Your lordship kindly see.
Where's Subramania?
Yeah. Your lordship's order is 16/8/24 plus.
Yes. Yes, Subramania. Records have been traced out. How about the new team that has been constituted?
Lordship, they have been asked to file a report, Lordship, by the Director of Higher Education, but that has not been placed to the Director of Higher Education. It has been said that, Lordship, it will take 1 to 2 weeks time, Lordship, for them to furnish the report, Lordship. And accordingly, Lordship, the higher education will pass out as well.
The new team.
Yes, sir. Already they have been sought to place a report, Lordship.
Okay. My lord, I'm appearing. Your lordship, recollect on the last occasion. It is their petition, whether records is important or not. They have filed the writ petition. In the writ petition, a comparative statement they have given. In the comparative statement, I am number 1, where I have been selected and appointed. My learned senior friend's client is number 5. So they made a party, they made 2-3 parties, they made who is above them. But during the course of the argument, they decided to strike off 2 of the respondents. Who is above them? So whether point A is whether they are agree person or not. Point A. Because second person who is below me should have come to the court saying this is my grievance. Number 5. Number 5, your lordship will kindly look into number 5. I have demonstrated. Kindly see the comparative statement, my lord. Whether at all records is necessary, that's why I'm projecting before the court. Kindly see the comparative statement at page 32. See page 32, my lord. That's their whole case petition. Kindly see number 4 is the respondent number 7. That is me, my lord, before this court. My marks grand total on the right hand side of the column, kindly see 61.25. Lordship got it? 61.25. Now, the petitioner before your lordship is at serial number 11. Muqbil Hussain Khan. Lordship looks into it, grand total 57.37. Please note, my lord, 57.37%. Now, there are other respondents, kindly see where they decided to strike off during the course of the proceeding is 16. That is Dinesh Sharma, R11. Kindly see R11 where they decided to strike off and percentage is 59.23. Apparently, it is above the petitioner. Now, if your lordship now looks into serial number 20, this is R10. R10 who has been strike off, the percent is 59.65.
No.
That is serial number 20. Serial number 20. R10. They decided to strike off. Total mark is 59.65. Lordship, right? So this is number 20. Now 19, who has not been strike off, Shruti Dhara Kashyap, 12, whose percentage is respond number 12, 58.92. Now, my lord,
11 and 10 has been struck off.
11, they decided, the court was asking, on their own valuation, on their own particular, they have struck off. They said that we don't want, because their proceeding is delayed, because they have to call off this party. You have to hear the party. You have to hear the party. They decided no. What we'll decide? We decided to strike off. And there is an order, 8/11/2017, there is an order passed by this court.
8/11.
8/11/2017. Kindly see 8/11/2017 order.
Yes.
So they decided. During the court said, okay, when you have decided what we'll do, we'll strike off. Now, what remains is only in respect of respond number 12. 12, I don't know, my lord. Nobody has, as my information goes, it has not been represented. The mark of respond number 19 is the serial number
19 is 58.92. So there are apparently 4 respondents. One, I am serial number 4. Respondent number 4, I am the highest, 61.25. I am number 1. Respondent number 4. Now response 7, I'm sorry, respondent 7. 10 and 11, which is serial number 20 and 16 has been struck off by the virtue of the court's order. 16, serial number 16, who is respondent number 11, and serial number 20, who is respondent number 10 has been struck off by the court. What remains is serial number 19, R12, who is apparently higher than the petitioner.
How about the R 8 and 9?
8 and 9.
Who are they?
8 and 9, I think they are the official. 8 is the principal.
Okay.
Principal, 9 is the principal, 6 is the principal. No, number 8 is also the principal Rajgir College. 6 is principal come secretary of Nobility College. 9 is the headmaster. 9, my learned pen is appearing for 9. And 10, 11, 12 are the private respondents.
So 7 and 12.
Yes. And 12. And your lordship will look into the comparative statement of the marks.
Yes.
Now, if you see the prayer at page 17, kindly see prayer at page 17 of the writ petition. 17 is a prayer. It is prayed that your lordship may be pleased to admit, call for the record, issue a rule, calling response so cause as to why a writ of mandamus so and so, directing response set aside and quest the selection of respondent number 7 as assistant professor in economics of so and so by selection committee wide resolution dated 5/3/2014, an appointment letter dated so and so, and direct the respondent to select and appoint the petitioner as assistant professor, as the petitioner is the first eligible candidate for the post of assistant professor in the interview held on so and so after hearing party perusal of so and so, so and so. So now what it has been projected that he is the first eligible candidate. Apparently from the, my lord, from the comparative statement, it doesn't appear that he is the first. He should be first. If my appointment is set aside, thereafter he will be the first.
Yes.
So he will be the first. Now the question is that why these marks all are above? Tomorrow, my learned senior friend may argue, no, respondent number 10, 11, their marks should not be A, B, C, D. But this, they have to be a party to it. Is it that you, without them, court cannot decide it? I think your lordship will not decide without them. They decide a voluntary that we will strike off. We don't know. You made them a party. What about the party now, not before the court? The party, which they have not strike off. Shruti.
Supposing this court strike off your, cancels your appointment.
Yes.
Then 11 and 10
Even then, how he will come? He will not come. He will justify before the court. Suppose your lordship cancel. Now find that my appointment selection was not. Now another question crops up. My selection, he said I should not have got that 2 marks. His whole grievance is that 2 marks has been given as a teaching experience. If your lordship looks into it, I have looked into the petition. Comparative statement, teaching experience, 2 marks. They said I am not entitled to get 2 marks. Very well. 2 marks you just minus 2 marks. Then even then I'll be above. Now, the marks which is given to my learned senior friend's client is teaching experience 4 marks. You are not entitled to get. At that relevant time, by the memorandum, it appears, memorandum clearly says, when you are pursuing a study of MPhil or PhD, then your teaching experience will not be counted. Please look into that memorandum. At page 22, at 7, column 7, 22, page 22, this is office memorandum. Selection procedure, my lord. These are selection procedure.
1 minute.
At page 22. See the selection procedure, 25th of this procedure. Whenever selection takes place, this procedure they adopts. See at 7, 6, 7, the period of time taken by candidate to acquire MPhil and or PhD degree shall not be considered as a teaching research experience to be claimed for appointment to the position, clause 3.90. If you see at page 24, teaching experience, kindly see at 24. 24, teaching experience 5 marks. Teaching experience 1 mark for each completed year of service in an affiliated government last degree college, subject to maximum 5 marks. That is, you will get 5 marks. Now, if you see, now if your lordship looks into my affidavit, which has been filed, affidavit in opposition.
Anyway, let him argue.
No, that's okay, fine. Your lordship has pointed out, that's why I think that whether, because why I have to open, my learned friend, senior friend will open the case, but the only is that whether records is necessary or not. Because a lot of time was given on the basis of the record. They are saying the records are not there, they have to construct a new records. But apparently on the basis of the competition.
Are you continuing in service?
I am continuing. I am continuing. There is absolutely no problem. I am continuing. Now, how many years? 8 years. I am continuing in my service.
My case lies somewhere else, my. The lawsuit is a paragraph 9 and the affidavit paragraph 11, my. Paragraph 9, your lawsuit condition. My whole case is, my lord, that she has filed this, all the paper documents after the interview was over. She was not eligible at the time of filing my but page paragraph 9, page 9, your lawsuit condition. Affidavit of paragraph 11.
Okay, fine. If the respondent number 7,
Yes.
if your grievance is against the respondent number 7,
Yes.
supposing the court takes notice of the discrepancies that had occurred at the time of selection and whatnot, and we say that his appointment was not proper,
Yes.
and it is set aside.
Yeah.
Will you get the appointment?
Yeah, paragraph 19 can be seen, madam. Paragraph 19.
Will you get the appointment?
Writ petition, paragraph 19. Page 14.
Yes.
I have described that they have not submitted papers that the petitioner state that one Tikendash respondent number 10 has got 59 point, but the respondent number 10 did not submit paper publication. He has not international standard book. There are requirement of any 3 international standard series so and so, so and so. Not submitted any seminar certificate. So respondent 10 will not get in poor marks in so and so. 46 marks he will get as per calculation. Well, then paragraph 20. About respondent number 11.
You'll get 47.
47.
Are they not supposed to be hurt?
Madam?
Are they not supposed to be hurt?
That's true, my lord. That
How did you start?
only question, my lord, to the information, I do not know, my lord, whether it's authentic or not. They are not interested, so that has been told to us, my lord. I don't know, my lord. Actually,
No, who is not interested?
that those persons whose name have been stuck up.
How do we know that they are not interested?
That is so. So I cannot say with certainty, my lord. That is what instruction has come.
The issue is,
Yes.
above you, there are other respondents. Respondent 12 is also there.
Right.
Then 11 and 10.
All of them
10
I have
and
described, my lord.
that you have described, that contention this court has gone into.
Right.
But in the absence of respondent 11 and 10, can we decide this case?
That's too much. So far, they are concerned, 10 and 11 is,
Because what you are saying is they were also not supposed to get so much marks.
yes.
After deducting this mark, they get 46.65. Another one 47.23.
So that information, but with authenticity, I cannot say, madam, because I cannot take the responsibility, as has been informed by them. In that case, my lord, let us again make them party. That is the only,
No, how can we again make them party?
this is the only option to get the action, my lord.
How?
Because this is already gone. It is already stuck off my.
You struck off their names
Yes.
on your prayer. On your prayer.
And
court
now this
struck off
question
those
has come. Now this question has come.
No, that question was already there. When you filed your writ petition,
Now,
that question was already there against the respondent 11 and 10.
Yes.
Knowing fully well that you are also challenging the marks obtained by them, you decided to strike them off. How can we bring them back again?
No, that of course, my lord.
That proposition you'll have to study and come back.
But
Because once you file an application for impleading them again, obviously they'll have your objections. They'll have to file your objections.
no, they will file objection later. Nothing. They may file, my lord. Just certainly, my lord. But my only question, actual action which have been informed to our my lord and council, my lord, whether that is correct or not. That only should be that way. Only that much, my lord. If that is correct, they are not interested. Okay, my lord. If they are interested, then of course that in that case, stock of that will remain, my lord. Whatever it may be. Your lordship may not.
In the absence of the respondent 11 and 10, supposing
Yes.
this court is just assuming
Assuming
7
I
goes.
understand what. Yes.
Let 7 go.
Yes.
A few again, there are 11, 10, and 12.
So that the committee will decide, my lord. Committee will decide. Suppose my question, my lord, if the managing committee has made any foul play or not. They have, my lord, actually what happened, my lord, especially we have stated. All the persons, my lord, all who are getting above me, that the respondents as well as respondent 7. They have especially they have given marks just to deprive me, my lord. That is what my case nullified.
That's fine.
This is my
we
case.
we understand your case.
Yes.
Just to deprive you, they've given to extra marks.
Yes.
But they're not before this court. This is what this court is saying.
So,
you have the first issue
in that
is
case, suppose
whether we can decide this writ petition in the absence of respondent 11 and 10.
so if your lordship, suppose if your lordship assuming your lordship set aside that order, let that selection committee go through the first thing, my lord, in that taking into consideration of the action which I have made, my lord, in that year. And governing the whole problem has been created by the governing body, my lord. Whole problem is created by the governing body. Selection committee or higher authority, whoever is my lord, genuine marks, whoever is entitled, I have nothing to say, madam. Genuine marks is to be given, madam, on the basis of the document which they have submitted at the time of application. Suppose if somebody is my respondent 10 and 11, suppose he is above me. And if he gets my lord, naturally, my lord, naturally, I'll have nothing to say.
But there are only the allegations against them.
No, my allegation is basically respondent number 7.
Either-
Basically.
Either you withdraw the paragraphs 19 and 20.
Yes.
It's your you'll have to withdraw 19, 20. Once 7 goes, automatically then one of them will have to be appointed.
One of the money, whoever is found, my lord, on the
Governing
not
body
on
has
the
made-
basis of the marks which they have
governing
given.
body has made the selection.
Yes.
Send it up for approval,
Yes.
approval made and then appointed. Something you'll have to think about this.
I just give a quick response to that, that whether your lordship can again ask them to omit these 2 paragraphs. Because omitting these 2 paragraphs where they made a statement before the court, I think with greatest respect, I'll say that at this moment. Number 2,
I agree,
number 2 is that it's very important whether they at present, without the other, which is number 5, whether he is really an agreed person. Number 3, selection committee, if you say that these marks has been given by selection committee and you are raising malafide, of course you have to make them a party.
That is not a
Which
party.
I have seen, only the principal and rest selection committee has not been made a party.
But
Please
principal
look
has,
into- Principal, my lord, is not only the selection committee. Please look into it. All that is a flaw of this writ petition line. How your lordship can entertain writ petition where they are raising malafide. How these marks are
against
given.
principal, yeah, madam.
Principal, my lord, what about the rest?
Governing body is there, madam.
See, there are series of judgments of the Supreme Court. You raise malafide, you have to make them a party. No, not make a party.
Governing body is made party, madam.
You don't make a party raising allegation that is a malafide. Apparently, my lord, I don't want, my lord, to trouble with your lordship with judgments of.
Governing body responded on 5.
Yes.
That is also struck off.
No. 4 not stuck off.
5 is struck off as per the.
No.
As per the noting of
5 is the main person, yeah, madam.
registry.
Oh, 5 by the governing body, 4.
IA 1239 of 2016.
Huh?
Oh,
2,
they
5.
have struck off.
2, 5, 1.
Oh,
1239.
5, 2, 5. ठीक है, 2 5.
They have struck off. They struck off full then.
Petition देनी.
I think they have struck off what my learned when it say.
कौन.
It will struck off full. I don't know.
2 5 हो गया था तो এটা 4 গেছে governing body. তারপর এটা 5 4. 4 দেবো রে. কোন আছে 5 দেবো?
Okay, 4 is also there.
4 cannot be my lord. 4 stuck on again.
Is IS civil number
No,
1239.
Yeah, it says, the order says that there are 2 respondent number 5.
Yes.
And the second respondent number 5, that is the governing body,
Yes. First is governing body, madam.
corresponds
Oh.
to
There
respondent
are
number.
two respondents. Yes.
Corresponds
Oh.
to respondent number 4.
Yes.
4
So
not stuck
4
off.
4 is the governing body.
Hmm.
So that other 5 has been struck off. So
Why not
governing body
5?
is still there.
No, what is there? 4. Now suppose 4 is a governing body.
Hmm.
Now your
No,
lordship
no,
knows.
that's a different, selection committee
No,
is something else.
If 4 goes, 5 will not remain because they cannot make president governing body. Governing body has to be made a party. Governing body also and so.
No, governing body is a party.
Representing
Number 4.
now 5 they have struck off.
No, 4 is there.
4 is governing body.
4 corresponds to the second 5.
Yes. Only.
Second one is same this is same.
Same name.
Oh, church.
Same this is.
So it was,
Oh, one is president
Ah,
and one is a governing body.
that is there. It was
They only have deleted governing body.
না governing
No.
body দুটা হয়ে গেছে.
there are 2 governing
2
bodies,
governing body হয়ে গেছে.
4 and 5.
1 5.
Oh, I have not got that copy also. I don't know. First time I'm looking into it. This copy also has not been received. That's why my copy doesn't indicate.
But what was first in presence of you?
No, maybe I am not saying, but I am. Anyhow, my lord, with great respect, I am saying this petition at all is not maintainable.
Yes.
You cannot rectify one after another. Now, my lord, number one, that you now say that no, I have grievance. Now, your entire repetition, the entire structure of the repetition is raising grievance against those private respondents.
Against principal.
Then, my lord, you have
Principal.
not raised any.
Respondent number 6.
My lord, 2, 3 things. Selection committee, malafide raising, you have not raised any point. So any marks which is given, that should be taken as correct, true and correct. Unless it doesn't come up before decay, these are the selection committee members. So these 2 marks should not have been given. They have not said. I think writ petition doesn't devoid any of merit and it should be. That's my humble submission.
We can dispose it off.
Page
Yes.
34 minus.
Hmm?
Kita dise. Resolution minor. Page 34.
There's no point of going into all this.
No, my whole question, my
Number one,
whole allegation against.
Selection committee is not party.
No, election against principal, whole case against principal. Principal by telephonic, by the information, ask the respondent seven, you submit your paper after the interview. It is admitted by respondent seven in the affidavit also, my. So my whole case against the principal. He is required-
Was the principal the only selection committee?
No, naturally principal is secretary and come
That's what
principal.
I'm asking. The selection committee is not a party. Respondent 11 and 10 are not parties. Then what more is left? Full of defects. We'll close it, close the writ.
Settle better. Photo করবো। না dismiss করবো। Better to withdraw, my.
You want to withdraw? Okay.
Let them
Mr.
enter my-
H.R.A. Chowdhury, Leonard, senior counsel.
With the liberty, my lord, from the.
There is no liability. That's
My lord, something you lost.
See, my lord,
My
this
junior-
is going from 2016.
Actually,
What torture? What
I
is
have
the-
also entered in the subsequent.
It's a torture, my lord, torture to us.
Press for withdrawal of this.
But you are enjoying.
No, maybe I'm enjoying, but no
liberty to
criticism
find
is
us.
out.
No prejudice will be caused.
Yes, no, of course, my lord, they will come at some other, my lord, my respect submission, that
Higher education, Mr. D.O. Parmania, Leonard, standing counsel. Higher education, appears for respondents, 1 and 2. Deputy Commissioner, Mr. G. Beku, Leonard, Governor Advocate, appears for the respondent, 1 3. Governing body,
4, 5 and 6.
Mr. K.U. Ahmed, Leonard Council, appears for the respondents, 4,
5 and 6.
4, 5 and 6. Mr. D. Das, then a senior counsel. Assisted by Mr.
E. Mohammed.
A. Mohammed, appears for the respondent number 7. And MS P. Bora, Leonard Counsel, appears for the respondents 9. With petition is dismissed on doubt with liberty as per.
Obliged to.
On 8/6/2017, my lord. Then, my lord, the state preferred an appeal in 2018. There was no stay in the appeal. We filed contempt, my lord. They took time, my lord, that we state had filed appeal, therefore they are not complying. Appeal has been dismissed, my lord.
Where is that?
We have filed IA, my lord.
IA?
Lordship. For impleting the new incumbent, we have annexed the judgment of the division bench. And appeal has been dismissed, my lord, 18 months back.
What is the number? IA?
1205.
120.
Page 18.
It is not this.
নতুন director. Include হয়ে গেছে তো। Page, my lord, 8, my lord. This is the judgment 17 to 2023. Now 18 months have already gone, my lord, no compliance till date.
No, I'm appealing for
Therefore,
the-
my lord, the
One minute.
contempt proceeding may kindly withdrawn my case.
Yes.
Lord, I'm appealing for the newly impeached respondent, my lord, the director, my lord.
Hmm.
Lord, I'd like to file my affidavit because since my joining, my lord, I'll to apprise the court, my lord.
How about the other one? The respond number 1.
Respond number 1, I don't know, my lord. Notice service.
You are appealing for 1 also?
Respond number 2, my lord.
Earlier appeared, my lord. Their name has been shown.
My wakalatnama is for respond number 2.
And respondent number 2 received the judgment of this Honorable Court, my lord, on 23/2/2023, page 7, my lord, in the IN.
Yes.
18 months back.
I'll file my affidavit.
Okay. You want to file your compliance report?
Well, I'll file my affidavit because from my end, my lord, the director has already communicated to the government, my lord. On immediately on receiving the notice on 1/6/2023, my lord.
Okay, fine,
Direction of this Honorable Court, my lord, to the director, not the government, my lord.
Stop.
Mayor communication is not compliant.
Mr. B. Kaushik, to your counsel, append corresponding. Grace for
2 weeks time.
2 weeks time to file affidavit. Prayer is allowed as a last chance.
Well,
Please, the matter. again
7 years gone, my lord, he has not been joined.
on after puja.
Well, before, my lord, because, my lord,
Oh,
7 years already.
Okay, third.
Deeply obliged.
my lord, I think 3rd of
October.
my lord.
9 to 12.
May I please, your lordship? Lordship, in these cases, my lord, we have challenged the advertisement dated, my lord, 21/2/2023, my lord, whereby, my lord, appointment of lecturer, technical and non-technical, my lord, of Assam Polytechnic Colleges, my lord, has been issued, my lord, along with the Dhemaji Engineering Colleges. My lord, if remember, my lord, yesterday, this supplementary item number 91 and 92 already heard, my lord, from the respondent side, my lord, the learned advocate general has argued the matter, my lord.
That review matter.
Yes, the two reviews matters, my lord. The same, my lord, advertisement has been challenged, but our case is that, my lord, we are already, my lord, holding that, my lord, post, my lord, as a 3F appointee, my lord. And time to time, our posts are, my lord, extended time for the, my lord, 4 months, 3 months like that, my lord. Till now also we are holding, my lord. And the last extension was given as a, my lord, it says, my lord, as the last extension, my lord, till the completion of fresh recruitment process, my lord. Which is, my lord, is supposed to be completed as, my lord, AG has already, my lord, informed the honorable court that within 15 to 20 days, my lord, result will be declared, my lord. My lord, today, my lord, my main fact is that the respondent has not filed the affidavit, my lord. Can it be on Thursday, my lord, for final disposal? Because within 15 to 20 days, my lord, if the result will be declared, my lord, these matters also become infructuous, my lord. Because it is the same advertisement is along with the review petitions, my lord.
The orders states that till the post is filled up by regular.
Yes, my lord, the last extension order, it says, my lord, it is not in the record, my lord, it is the last extension, my lord.
Let us see.
It was extended time to time, my lord, since 2021, since we are appointed, my lord. Since we are appointed under regulation 3F, my lord. Last line, my lord. As, my lord, the learned AG yesterday informed that within 15 to 20 days, my lord, the interview since already held, my lord. This select list will be published.
Did you appear?
Some of them appeared, my lord. But some of them not appeared because their age is already over, my lord. So before, my lord, publishing of select list, this case also may be heard, my lord. On the next Thursday, my lord, if convenient.
Who appears for the other side?
Technical, my lord, he may appear.
Higher. Gogoi was appearing on the other day.
Yes.
The other day.
Yes.
Similar petition has already been disposed of.
Connected.
Not connected.
Not connected, my lord, but the issue is, my lord, somehow related. Our prayer is, my lord, to set aside the advertisement and the, my lord, since we are holding that post, my lord, 80 posts, my lord, and
But in the other case, this court has already said that we are not interfering with the advertisement. Of course, that's subject to the review application.
Yes, my lord, but we have some other grounds also, my lord, since we have given the ex post facto approval by the cabinet decision, my lord. Therefore, my lord, our posts are a sanctioned post, my lord.
There are some grounds, my lord, therefore.
Here, their ground is, my lord, that they have been appointed under 3F, my lord. So
So,
now they are saying that
after meanwhile, my lord, it was given approval by the cabinet decision, my lord. That was also, we have taken the pleading in the, my lord, petition. That's why, my lord, take it up for final disposal on the next week, my lord. We'll argue on that.
next week. Next week.
Okay.
What are they? 86. Those cases, my lord, we are yet to file affidavit.
Well, in the meanwhile, if they want, my lord, because after 20 days, it's selected, it's published, my lord, this matter will automatically become infectious, my lord. That's why, my lord. Yeah.
In any case, I think this matter has become infectious.
No, my lord, since, my lord, these, our services are already extended till the
Thereafter, my lord, their services has not been extended after that.
No. Their services were extended till completion of fresh recruitment process. So the fresh recruitment process is going on now.
Going on, my lord.
So after that is over, their appointment goes.
not
Unless they are selected in that recruitment.
Yes, my lord. Or if
And, my lord, and then in the interim also, my lord, selection, my lord, in the interim, it says selection will be subject to the outcome of the writ petition, my lord. In the interim, in all those, these 4 cases, my lord, order dated 22/3/2023, my lord. Mates.
22?
20, my lord, 03/2023, my lord, 20 March 2023. As an interim, it made subject to the outcome of the writ.
Google, similar matter?
Lordship, similar. They have also challenged the constitution of the board, Lordship. That was also upheld by the Honorable Division Bench of our High Court, Lordship. Similar matter, Lordship. Similar.
3F.
3F, Lordship. Here it is a settled position of law, Lordship. 3F, Lordship.
So what you want to do? No affidavit has come.
Lordship.
Final disposal.
Otherwise, Lordship, we can argue on the basis of the settled position of law, Lordship. And if Lordship permit, we can file also short affidavit also, Lordship.
File a short affidavit, we'll fix it on 26.
26, it will be bigger. Let it come on after vacation.
What he's saying that if that
select list will come,
Then Lordship may hear it, Lordship. We will not file. We will place on the basis of the.
Okay, you try to file your affidavit.
Lordship.
If you can't file your affidavit on the question of law, we'll.
Lordship. My lord, no need to indicate, Lordship. We'll try to file, Lordship. Otherwise, Lordship will argue on the basis of the law, Lordship.
Okay, heard, Mr.
Well, S Hazarika.
S Hazarika and a counsel for the petition. As well as Mr. K. Gogol and a standing counsel, higher judicial.
Lordship.
List this matter for final disposal on 26th.
Lordship.
I'm deeply obliged.
Otherwise, I think the matter has become infructuous.
Lordship.
Of course, subject to the review. What this court says.
Yes, my lord, I agree, my lord. Some of the prayer is remains, my lord. 1, 2, 3 pairs are already involved. I can understand, my lord. There are some other issues, my lord.
Regarding non-technical part, Lordship, already Honorable Courts directed, Lordship, it was already completed by the FPSC, Lordship. It is all appointment letter was also issued, Lordship. Only technical was as per my lord's direction, we are on the process. Lordship.
Obliged.
13. The constructing.
Lord, Lordship may conduct order dated 9/8/2024. Lordship may conduct the order dated 9/8/2024. 9/8.
2024. They'll have to produce the instruction as the proposal sent to the government, my lord.
Yes, secretary.
He does.
He does appear to the record is not with us, Lordship.
See, last occasion, they said that the proposal for error salary has been sent to the secretary. Now this court wanted to know the latest status with regard to the said proposal.
Current salary is been is getting, my lord, by the
You're
petition.
getting the current
Yeah,
salary.
right. So what the areas range? The similar order also passed, my lord, 14-6, 19-7.
Okay, heard, Mister?
Yes, Lordship, may kindly pick it on.
Excuse me, Majumdar.
PB Majumdar. On request made on behalf of MSB Das, Leonard's standing counsel, secretary to the court. This is the matter on 25th.
Right.
14.
May it please, sir. My lord, the matter is dismissed for default, my lord. On that day, my lord, I went to
Where's the order?
Miss case 42, my lord, page number 9, my lord. My lord, I went to cast vote in the Lok Sabha election, my lord, on that day, my lord.
That was dismissed on 26/4.
Yes, ma'am.
When did you file this MC?
My lord, earlier I filed another restoration, my lord, that was withdrawn. Some defective was there, my lord. So, my lord, there is a delay of 9 days, my lord. And due to delay, my lord, I have filed a condemnation petition also, my lord. That is miss case number 2056. IA 2056. No, 9 months. Restoration.
Okay. Restoration. Means कि ध्यान idea copy नहीं restoration file को not in a delay sir.
No, then there is restoration.
Yes. We can condone the delay like this. But Mister
Ali.
K. Ali, learning counsel for the applicant in the IA. By this application, the applicant who was the writ petitioner in WBC number 498/2017 is praying for condemnation of 9 days delay in filing the connected miscellaneous case. Stop. Mr. S&T Chief Still, understanding counsel. Elementary education. Department has no objections. This court has also perused the course shown in the present application and is satisfied. And accordingly, the delay of 9 days in filing the connected this case is allowed. Yes, disposed. But then there is a private party.
They will appear at the time of hearing, my lord, main case, my lord.
No, before that restoration, they have to be heard.
For restoration, it has to be heard.
They have to be heard.
Even delay.
But they have to be heard.
They have received the notice, my lord.
Restoration.
Restoration, my lord.
Have you served no copy?
My lord, my clerk has served, my lord.
You don't know.
Or he can submit a dusty and give a affidavit, file an affidavit before this honorable court. That will, and then may kindly.
My lord, my lord, it may be listed again, my lord, by showing their names, my lord. That will be that will do, my lord. By showing their name.
They have not appeared.
They are appearing in the main case, my lord.
That has been dismissed, right? Okay, so to dismiss.
That is already finished.
That is finished. That has to be restored.
Now notice has to go.
I will inform them, my lord. They will.
No, they can't, you can't do that. It has to go, you take the service of notice by Dusty.
And file an affidavit to the honorable court regarding that. My lord, I will inform the learned counsel that he will appear.
Those councils who engage in the writ petition, that writ petition is already dismissed. I mean, for non-prosecution. Now that this is the for restoration, I don't know whether the party will engage the those
Again
same
or
writ,
not? Yes.
or do you want to engage some other councils? That is the issue. But Mr. So and so, learned counsel for the applicant. Issue notice. None. And this is an application for restoration of WBC number 4982 of 2017, which was dismissed for default on 26 for 2024. Stop. Issue notice. Mr. S.M.T. Chishti, then a standing council, elementary education affairs for respondents, 1, 2, 3, 4, 4. G. Beko, Leonard, government advocate, affairs for the respond number 5 and 6.
Yes.
Circle officer also?
Yes, yes.
5 and 6.
My lord, that's the only method.
Okay. Petitioner is directed to cause service of notice on the respond number 7 by Dusty Service to the registry of this court within a period of 1 week.
No.
Draft a comma. The petitioner shall file an affidavit to that effect. List after 2 weeks.
Yes.
15.
I have filed a miscase, my lord.
This is
for the respondent university, my lord. Mr. K. N. Chaudhary will lead me in this case, my lord. My lord, it is in tune with the division bench judgment, but a stay order has been passed, my lord, on 6th. So, my lord, we have filed a miscase, my lord, along with affidavit.
the order?
On
It's page
6th.
44, your lordship. But lordship, I appear for the respondent in the matter. We require some time to file an objection.
Since, my lord, there is an urgency, my lord. My lord, by 23rd, my lord, they may file affidavit in opposition, my lord, and we will file reply to that, my lord. 23rd only 1 week.
Now, what has happened in this matter, your lordship, is that the petitioner was appointed and he was confirmed as a professor. There is a certain aspect of subjective appreciation of the petitioner's credentials. Now, the authority, rightly or wrongly, they are seeking to revisit the entire subjectivity criteria of the petitioner again. But so that be that as it may, your lordship will need some time to satisfy this court on the averments which have been raised by my learned senior for the applicant. We got some time to file an objection to the matter, your lordship.
Okay, heard Mr. P.G. Fukan, standing counsel,
KK Hendik, State Open University.
Krishna Kanda Hendik, State Open University. Public applicants. Issue notice. Mr.
M. Sharma.
M. Sharma, then counsel. Affairs for the respond number 1. And praise for how much time?
I pray for a week, your lordship, but the matter may kindly, subject to what your lordship determines. I have some personal difficulty till 27th. I've discussed that with a senior friend. The matter can be fixed as per his convenience, as per my senior's convenience on 30th or 1st. I leave it to your lordship.
Milord, by 23rd, Milord, they will have to.
We file our objection. That is.
Then, Milord, we will file reply to that, and the matter may come up on 30th.
For a week's time. File objection. Who appears for UGC?
It's a pro forma assistant, your lordship. A. Somua.
Osim Somu.
And Mr. A. Chamor, the next standing counsel usually appears for the pro forma respondent. List the matter on 30.
Milord, by 23, Milord.
We'll do the, we'll not default on that, your lordship. Interim to continue, your lordship.
No, this is an IA only.
This is an IA, but yes, it's a little.
In the writ petition, when is it listed?
The writ petition was listed on 6th of September. Your lordship had issued notices returnable in 4 weeks. No
Yeah.
fixed date has been given. So in the writ petition,
By then,
Most obliged.
16, hearing.
Lordship, would you be kind enough to allow the name of Mr. A. Somua be recorded for the UGC?
that's what I've done.
yes. In fact, till the next returnable date in the writ petition, the stay was operating. The returnable date is 4 weeks, but the matter is also tagged together with the IA. So I just take your leaves, lordship, that interim may be continued.
It will continue.
Yes, I'm grateful, your lordship. I'm grateful.
Most obliged.
May it please your lordship. My lord, lordship may recollect this matter, my lord. Lordship earlier heard this matter. This matter relates to the petitioner is my lord, constable in CRPF under the respondents. My lord. He was appointed in 21/1/2007, my lord, initially. Thereafter, my lord, he was granted leave to
1 minute.
my lord.
Petitioner was appointed.
As my lord, constable in CRPF under the respondents on 21/1/2007, my lord.
Yeah.
And my lord, page 20 of the writ petition, my lord. Page 18 is his appointment order. Page, now I am referring, page 20. My lord, initially he was granted 30 days leave, my lord. With effect from 6/1/2020 to 4/2/2010. 6/1/2010 to 4/2/2010. 30 days leave. My lord, while he did not return back, this Annexure 3, page 20 and page 21 was issued to him, calling him for joining duty, my lord. But why he could not come to join duty, he has stated in para 4 that he made an accident, my lord, in Delhi, while he was posted in Delhi, my lord. In para 4 he has stated. Now, my lord, for the
1 minute. These are notices.
my lord, yes. Wherein it is discernible that initially he was granted leave of 30 days. Now, my lord, yes. Now, my lord, for alleging unauthorized absence from duty, even after receipt of these 2 notices that he has not joined in duty, therefore, page 30, my lord, this notice memorandum was issued under Rule 27 of CRPF Rule 1955. My lord, page 30. My lord, the article of sirs is page 31, my lord, that he deserted colonial line on 14/10/2010 and still absconding without any information or prior permission of the company who is prejudicial to good order and discipline of the force. Primarily, my lord, this is the, my lord, sirs. Now, my lord, the inquiry was conducted. Now, inquiry, relevant portion of inquiry report was furnished. Now, from the, my lord, this page 36, this is a forwarding letter, and relevant portion, my lord, of the inquiry report, I will be reading page 38, my lord.
What date is this? 1990.
Yes. 2011, my lord. Inquiry report was forwarded.
Yes.
Now, my lord, from the inquiry, my lord, page 38, para 6, my lord, what I want to, my lord, say that he tried to spell out about his, my lord, medical illness. Lordship, kindly see, my lord, on analysis of the evidence, it is found that there is no information as to why Pankaj Baswara has absconded from the complaint, whereas on the basis of statement of Constable Pankaj Baswara, it is learned that he did not know anything as to what had happened to him due to his mental stress or illness. He absconded, but he has no proof that he has suffered from mental illness or stress. During his discipline, he did not make any communication with the company or the force, and though he appeared before the inspecting officer at the preliminary stage of investigation after he had been served notice to that effect, but on 19/7/2011, he again absconded before the completion of the investigation. In this way, Pankaj Baswara has neglected the order and violated discipline by absconding from the force. Now, my lord, what the witnesses have said, my lord, kindly see page 39, last two paragraph, my lord, on the basis of, para 13 with on the basis of. Page 30, on the basis of witness number 1, 2, and 3, Constable Pankaj Baswara was found to be obedient to his duty, but no information could be found as to why he had absconded. As per the version of the absconded and remained owing to his mental state or illness. My lord, the petitioner as well as the witnesses also, my lord, stated that he had some problem of medical ground, my lord. So ground is there before the inquiry officer, what I want to submit. Now, my lord, suggestion kindly see, my lord, page 40 by the inquiry officer. From the statements of accused and other documents submitted in connection with search level against Pankaj Baswara, and as the accused appeared before IO after he had been served with notice by the IO, but again he absconded before completion of the investigation. It seems as Pankaj Baswara does not want to remain in force. Therefore, on the basis of all the statement evidence, the investigation officer come to conclusion that the allegation level against so and so is established. Now, on this, these are the materials before the, my lord, now disciplinary authority. They have, my lord, passed the impugn order at page, my lord, 47. Page 47 and excerpt 12. 12/10/2011, my lord. Dismissing him from service. This is also I have taken account extra shocking to the search level and proof against the, my lord, delinquent. Para 5, my lord, page 48, kindly see, my lord. Before taking any action on the report of inquiry, a copy of inquiry report was forwarded to the delinquent at his known home address, post office, dated 9/9/2011, with a direction to submit his representation against the report, if any, within 15 days of receipt of the report. The delinquent has not submitted any representation till date. Therefore, after taking into taking into consideration all the aspects of the case, I am of the opinion that delinquent number Pankaj Baswara deserted from the line unit 14/10/2010 about so and so, and he reported back at his own, my lord. Once he was declared deserter, my lord, if a deserted person reported back of his own, my lord, and they have not find me out, then, my lord, deserter the goes, my lord, in my humble submission, my lord, that I will show, my lord. he reported back at his own on 1/7/2011. But my lord, again on as per them, my lord, 19/7/2011, my lord, he again absconded. No, I do. 19/7 পৰা abscond হয়ে। ঠিক আছে দাদা, আপুনি বাকীখিনি কৈ দিব। Now, my lord, total days, kindly see para 6, my lord, they have my lord, calculated in the disciplinary authority 347 days, my lord. There are because on 1/7 he joined, my lord, again from 19/7 he again absconded or deserted, my lord. And therefore there is a total of 347 days. Now, my lord, by this order, dismissed from service. This is the my lord, order pass dismissing him from service. Para 5, my lord, last 3 lines, my lord. Pankaj was the penalty of dismissal from service. It's a bold description. Now, my whole contention before your lordship in this present my lord, proceeding as well as the earlier proceeding, why I'm saying, my lord, once this writ petition was dismissed, thereafter we preferred an appeal, my lord. And in that honorable division bench, appeal has been allowed, saying that there is procedural lapse. The manner in which the disciplinary authority or the inquiry officer required to prove these charges, that finding is not there in the inquiry report. My lord, on the basis of the judgment, Kusan B. Parmar reported in 2012, my lord, last occasion I placed the judgment, my lord. 2012 3 SAC 178. On the basis of this judgment, my lord, this is also a my lord, discipline force. This Kusan B. Parmar case also, my lord. In the judgment, there was a absence of 234 days. Para 11 of the judgment, my lord. 234 days. Now, the Honorable Supreme Court what say para 17, 18 and 19, very important, my lord. If, may I read these 3 paragraphs, my lord?
Yes.
My lord, para 17, my lord, if the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence can be held to be willful. Absence from duty without any application of prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities as due to which the employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee can be held guilty of failure, devotion of duty, or behavior unbecoming of a government servant. In a disciplinary proceeding, para 18, my lord, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In para 19, in present case, inquiry officer on appreciation of evidence, though held that the appellant was unauthorizedly absent from duty, but failed to hold that the absence was willful. The disciplinary authority, as also the appellate authority, failed to appreciate the same and wrongly held appellant guilty. That's my same case here, my lord. What I am saying, my lord, that the inquiry officer has not come to a finding, my lord. You remain absent. So therefore, from the evidences, it is found your conduct is willfully, you are absented from the duty. There is no word in the my lord, inquiry report that willful. Even that word is not there. Now, since the my lord, inquiry officer failed to come to a conclusion that his duty is willfully he absented from the duty. So therefore, his absence may be unauthorized absence. My lord, as per this judgment, my lord, all unauthorized absence shall not be my lord, the term is willful. Until and unless it is proved before the inquiry officer and the inquiry officer come to a definite finding to them. What is lacking here, my lord? My lord, on the basis of this judgment, the Honorable Division Bench, while allowing the appeal, my lord, writ appeal number 164, and I have placed this also, my lord, earlier. And writ appeal number 164 of 2022.
1 minute.
My lord. This is of date, my lord, 27/4/2023, my lord. Writ appeal number 164. My lord. My lord. Lord, this is the very same case. This was dismissed, my lord, by judgment dated 17/3/2022. Thereafter, we prefer an appeal, my lord. In that appeal, my lord, statement of article of search has been, my lord, noted by the Honorable Division Para 3, my lord. Then my lord, Para 4, my lord, the Honorable Court has noted that initially he participated, thereafter he again absconded, my lord.
Yes.
My lord, here, my lord, very important, my lord, our submission has been noted. So far, the petitioner appellant was Para 6, my lord. Then so far, the Union of India Para 7. Now, my lord, Para 9 is very important, my lord. May I read, my lord? At the outset, we may note that there is inherent lack of resolution, willful absence in the article of search, as well as the order imposing penalty. The pertinent grounds spell out from the pleading in the writ petition is that no allegation against the appellant petitioner being willful absent from duty. This is the objection made by the union, my lord. In this regard, we would like to refer the amendment made in paragraph 17 of the writ petition. I have taken this ground, my lord. This argument was raised before the learned single judge, which has been taken note at para 13 of the judgment, but in a contradictory finding at para 14 of the impugned judgment, the learned single observed that the petitioner has not made challenge to the dismissal on the order on the ground of procedural irregularities. The observations appearing in para 13 and 14 impugned judgment are inconsistent to each other. In view of this matter and having regard to the this preceding decision discussion, we are of the opinion that the writ petition filed by the appellant herein deserve fresh consideration on merit after adverting to the pertinent ground challenge laid to the impugned order of dismissal from service based on procedural irregularity as alleged by the petitioner. Hence, the appeal deserve acceptance. The impugned order judgment is hereby reversed and may be remanded back to the line of single judge for.
Where is the judgment of the single bench?
Yes. The judgment also I place, my lord.
I have.
Yes. (17/3/2022), lord. para 13 and 14 from this judgment.
Yes.
Lordship may take up with 200.
Lordship, I've got a small prayer, Lordship, I paying for a little accommodation, Lordship, I've got a fixed matter at 2 p.m. in court number 18. He can continue, Lordship, my colleague will be here, I'll come back and reply, Lordship.
But we'll
Lordship can hear him, Lordship.
Been found by the Honorable Division Bench in my humble submission para 10. And moreover,
according to you, what is the procedural irregularity?
procedure irregularity is my humble submission is that, my lord, unauthorized absence may be there. If a person without leave absent from duty, my lord, that amounts to unauthorized absence. Now, inquiry officer, in view of my lord 2012 Kusanbi Performance Judgment, inquiry officer has to prove that he unauthorized absence willfully. His unauthorized absence is willful. That willfulness is to be proved. What is lacking in this report as well as the disciplinary order, the authority order. Disciplinary authority order also not said that he willfully absented. Even I assume, my lord, or that there is unauthorized absence. Merely on the ground of unauthorized absence, person cannot be, my lord, impose punishment like termination or dismissal from service. What has been held by, my lord, that Honorable Supreme Court, my lord, in the judgment of Kusanbi Parmar. Just I shown, my lord, para 17, 18 and 19. 19 is only to that point, my lord, para 19. So that is my case, my lord. Here in this case also, neither the inquiry officer nor the discipline authority, that there is no whisper as to whether the unauthorized absence was willful. There is no finding. So on that basis, the punishment imposed is not sustainable in my humble submission. These are my submissions, my lord. Lordship may examine on this count, my lord.
Yes.
Whether he is another matter is fixed in court number 18. So if Lordship allows reply may be fixed on Thursday, the reply is on Thursday.
VK does learn the concept of petition. As well as Mr. Architect Dave Chaudhary, Leonard CTC, as Leonard Deputy Service Superintendent. For the response, please for the hearing. You can't hear me. When do you want?
Thursday, Lordship. 90. 5 years.
18.
This is regarding regularization of service, my lord. Other similarly situated person has been already been regularized, my lord. But verification of the petitioner's case, my lord, done by the BTC authority. And my lord, BTC authority sent the, my lord, proposal to the state, my lord. But it was sent lately, my lord. That is why petitioner was left out, my lord. But BTC has filed the affidavit. The education department not filed any affidavit, my lord. Their affidavit is required, my lord.
Yes, Lordship, there was a misconception earlier, Lordship, as BTC was there, but after I go through the page 18, Lordship,
it was clear that the petitioner was left out. And so that I need to obtain express instruction, Lordship. Lordship may post the mirror after puja petition, Lordship. I will file my affidavit.
Mr.
Acer Ahmed.
S. Kumar.
Understanding council.
Lordship. No, Lordship, I am for elementary education, Assam.
Date may be fixed, my lord.
Up to puja, I'm not.
My lord. Obliged.
19.
Time for response number 4. This is actually pertaining to a matter where an order by the learned educational tribunal has been assailed, wherein I have filed an appeal, initially assailing the order of suspension. And subsequently, during the pendency of that appeal, an order of dismissal from service was also passed. I have subsequently amended my memo of appeal to assail that as well. Now, here during the pendency of the appeal, initially I had filed a petition seeking direction upon the respondents for production of certain documents, which would be relevant in the context of the appeal. Now, there was an order initially passed by the learned educational tribunal wherein my prayer was rejected to the extent of calling for documents in a gamut manner, wherein I had actually asked for calling of documents from a certain period to a certain period. Now, that order that was rejected, however, with a rider that documents relevant in the context of suspension and dismissal of the appellant, who is the respondent number 4 herein, should be produced in original by the respondents in that case, who is the petitioner over here. Now, even after a lapse of more than a year, there was no documents produced by the respondent in that educational tribunal matter. Subsequently, we preferred another petition where we streamlined our prayer to the extent of specifying the documents which we felt are relevant for the purpose of establishing our appeal, establishing the contentions raised in the appeal. Now, that petition was allowed by the educational tribunal, and the petitioner hearing was notified and directed to produce those documents. Against that particular order, they have come up in writ before this honorable court, where basic contention that they have raised is that the subsequent order could not have been passed by the educational tribunal in view of the fact that earlier there was already an order passed whereby my prayer for calling for the documents was rejected. Now, to that, my lord, I have come up with my response also here. The pleadings are complete. And I also filed a petition for vacating of an interim order passed by this honorable court, wherein that particular order was suspended. And because of that, my appeal, literally, I am non-suited in a way, because if those documents are not allowed to be produced, my chances in the appeal literally gets negated. My learned friend is the petitioner. He will place the case. I'll take it up there.
Also, will kindly come to page 24 of the writ petition, my lord. This is the order by which the respondent number 4 was placed under suspension, my lord. Suspension from the post of assistant teacher with reference to the subject. Lordship's court.
Who are you?
I am the, my lord, principal.
Of the college?
Yes.
School.
Sorry, school, my lord.
Okay.
I would like to inform you that you are placed under suspension with immediate effect under proviso to section 15(2) of Assam Non-Government Educational Institutions Regulation and Management Act 2006, read with section 17,
A, B, and F of Assam Non-Government Education Institute Regulation and Management Rules 2007. The disciplinary committee has already been informed, which will conduct the inquiry in respect of the charges involved in a departmental proceeding drawn up against you. During the period of suspension, you are not to attend school until and unless required for the purpose of conduct of the proceeding that is contemplated against you. Thereafter, my lord will find the show cause notice. You are hereby required to show cause under Section 15(2) of Assam Non-Government Education Institution Regulation and Management Act 2006, read with Rule 21 of Assam Non-Government Education Institution Regulation and Management Rule 2007 as to why any of the penalties prescribed under Rule 19 of the said rules of 2007 should not be inflicted upon you basing on the following charges, along with the statements of allegations attached herewith. So will kindly appreciate the charges, my lord. Number one, that you without any authority and with malafide intention prepared an appointment letter dated 10/1/1995 on the letterpad of the school by forging the signature of the principal of the school, showing yourself to have been appointed as an assistant teacher of the school by referring to a non-existent resolution of the managing committee of the school. The existence of the said appointment order was not to the knowledge of the authorities of the school till the recent past. Further, by utilizing the fake appointment letter dated so-and-so, you have resorted to misrepresentation before the Honorable Guwahati High Court in the writ application being WBC number so-and-so instituted by you to plead that you have been in service of the school with effect from so-and-so, which assertion is clearly perverse. The forgery made by you of the signature of the principal of the school in the appointment letter dated so-and-so stood established upon forensic examination of the same. The above fact of yours reflect your malafide intention and upon your integrity. The forgery resorted to by you for achieving your nefarious intention has undermined the reputation of the institution. As such, by your above act, you acted dishonestly and in a manner prejudicial to the interest of the school. You are therefore charged with gross misconduct, forgeries, insubordination, misrepresentation, dishonesty, and for undermining the status of the school as well as the provisions of Rule 24(b)(2) of Assam Non-Government Education Institution Regulation and Management Rule 2007. Then number two, that from the RTI replies as received from the authorities of IGNOU, it is revealed that you had submitted an application before the authorities of IGNOU for pursuing B.Ed course and there had projected that you were working as assistant teacher in Emmanuel English High School, Pailapul with effect from 1995 and had submitted the experience and employment certificates required to be furnished along with and in connection with the said application by forging the signature of the principal of the school therein. The forgery made by you of the signature of the principal of the school in the said application form and also in the experience and employment certificates required to be submitted in connection with the said application forms to establish upon forensic examination of the same. The above acts of yours reflects your malafide intention and upon your integrity. The forgery resorted to by you for achieving your nefarious intention was undermined and undermined the reputation of the institution. As such, by your above acts, you acted dishonestly in a manner prejudicial to the interest of the school. You are therefore charged with gross misconduct, forgery, insubordination, misrepresentation, dishonesty, and for undermining the status of the school as well as the provisions of Rule so-and-so, so-and-so. Now, number three, my lord, that you, by misusing the trust reposed on you, prepared a fake appointment letter dated 10/1/2010 by forging the signature of the principal of the school, showing your husband Major retired Sri so-and-so to have been appointed as assistant teacher of the school, and to cover up the illegality committed quoted therein a non-existent resolution of the managing committee of the school. The managing committee of the school had never resolved to appoint your husband as assistant teacher of the school, and the principal of the school had never issued the appointment letter dated so-and-so. It may be mentioned here that as of 10/1/2010, your husband was a full-time employee of Bibbles International India Society at Pailapul, and thereafter in the month of October 2011 had joined M. Dev Singh Memorial Academy at Binakandi as assistant teacher. Your husband never served in Emmanuel English High Secondary School as an assistant teacher at any point of time. The forgery made by you of the signature of the principal of the school in the appointment letter dated so-and-so stood established upon forensic examination of the same. The above act of yours reflects your malafide intention and upon your integrity. The forgery resorted to by you for achieving your nefarious intention was undermined the reputation of the institute. As such, by your above acts, you acted dishonestly and in a manner prejudicial to the interests of the school. You are therefore charged with gross misconduct, forgery, insubordination, misrepresentation, dishonesty, and for undermining the status of the school, as well as the provisions for rule so-and-so. Number 4, the RTI replies received from IGNO also reveals that you had, for the purpose of securing an admission for your husband into the B.Ed course conducted by IGNO, by misusing the trust reposed upon you, conceal the fact your husband was not eligible for B.Ed course as he did not fulfill the eligibility, i.e. minimum of 50% marks in graduation, which is evident from his B.Ed application form. Moreover, being aware of the fact and the IGNO eligibility criteria, you, by taking advantage of the clause that the 50% mark shall not apply to those appointed before 30/3/2010, proceeded to manufacture a fake appointment letter dated 10/1/2010 and made false certification in the admission form with malafide intention for securing fraudulent enrollment into the B.Ed course for your husband. You were also aware of the fact that your husband was not a teacher in the school and still made contrary declarations, which reflects upon your integrity. You, by your such act, not only misled the authorities of IGNO, but also put the reputation of the school at stake. You had, for furtherance of your nefarious intention, resorted to forgery, misrepresentation, and misutilization of the seal of the school. Now, serial number 5, that you, in continuation of your nefarious activities, proceeded to issue further experience cum employment certificate in favor of your husband on so-and-so and so-and-so, projecting yourself as the headmistress of the school and utilizing the school seal without authority. You had certified in experience cum employment requisite to be submitted for securing the said admission that your husband Sri so-and-so was teaching in the school with effect from so-and-so and had teaching experience of 2 years, 5 months and 20 days and made such perverse assertion by misusing the trust reposed upon you. The projections as made in the certificate are false to the core of it, and you had resorted to falsehood only to secure undue advantage for your husband. Now, number 6, Miller, that from the undertaking given by MS so-and-so, wife of Sri so-and-so, daughter of Sri so-and-so, it is revealed that you had, without authority and by taking undue advantage of the trust reposed upon you, issued to them appointment letters showing them to have been appointed and working in Emmanuel English High School for the purpose of securing admission into B.Ed program conducted by IGNO. You had also, by projecting yourself as the headmistress of the school, signed on the application form submitted by Sri so-and-so and MS so-and-so before the authorities of IGNO for admission into B.Ed program and certified therein informations which on the face of it were perverse, in as much as MS so-and-so and MS so-and-so were at the relevant point of time not working in Emmanuel English High Secondary School as assistant teacher as projected by you. You had resorted to falsehood and thereby undermined the reputation of the school in the eyes of the authorities and public at large. Number 7, that you had, in clear derogation of the norms of the management of the school, tried to create a parallel management in the school, and with this intention, in connivance with few members of the erstwhile managing committee of the school, convened meetings of the managing committee outside the school premises and adopted resolution with the intention to take control of the school management. You had also, for the purpose of advancing your nefarious intentions, discussed matters pertaining to the school with authorities of education department as well as the district administration by projecting yourself to be principal of the school. You at no point of time were authorized by the school management to do any such activity. You had tried to usurp the management of the school for your nefarious intentions. Now, number 8, that you, without any authority and by resorting to forgery, had got illegally rectified the land documents standing in the name of Emmanuel English School, Binakandi, to that Moirangthem Deb Singh Memorial Academy. The lands covered by Roman 1 deed number so and so dated so and so, deed number so and so dated so and so, and deed number so and so dated so and so, bought and standing in the name of the Emmanuel English School Binakandi were illegally changed to Moirangthem Deb Singh Memorial Academy by falsely projecting that there was a typographical error in the original deed. We were also actively involved to change the name of the Emmanuel English School Binakandi to that of Moirangthem Deb Singh Memorial Academy by projecting that the same was so done under the instruction of the Inspector of Schools, CDC Silchar, and based on such misrepresentations got the said deeds modified. You had, for achieving the said objective, misrepresented facts before the concerned authorities via your communication dated 5/1/2018 and 1/6/2018. The fact that there was no instructions for change of the name of the school from the Inspector of School CDC Silchar is clear from the minutes of the meeting dated so and so held in chamber of SDO Lakhimpur Kam Additional Deputy Commissioner Kasal Silchar. The above acts of yours reflects your mala fide intention and upon your integrity. The misrepresentations made by for achieving your nefarious intention had undermined the reputation of the institution, and the fact that you had done so for obtaining undue gain for yourself is clear on the face of the connected records. As such, by your above acts, you acted dishonestly and in a manner prejudicial to the interests of the school. You are therefore charged with gross misconduct, insubordination, misrepresentation, dishonesty, and for illegally getting the name of the school changed to so and so without any authority and oblique or with the consent of the authorities of Emmanuel English School group of institutions as well as the provisions of so and so. You should submit your written statement in defense within 15 days from the date of receipt of this communication, provided you do not intend to inspect documents which have relevance with the issue under inquiry. In case you intend to inspect this document, you should write to the undersigned for the same within 7 days from the date of receipt of this communication and submit your explanation thereafter within 10 days from the completion of inspection. Your written statement stating whether you desire to be heard in person should be submitted to the undersigned within a period specified above. Statement of allegation and list of documents and witnesses are enclosed herewith. So by the show cause notice, my lord, opportunity was given to her to ask for document, to inspect for documents. The list of witness and the list of documents were also enclosed. The statement of allegations, lordship will find page 35. I will not read the statements of allegations because the contents will be same with some elaboration here. Otherwise, the allegations are already there in the charge sheet, my lord. Lordship will find the list of documents, page 42. Relied on by the disciplinary authority. There were in total 20 list of documents. Then list of witnesses, page 44. Then for page 45 is the application given by the respondent number 4 to the petitioner. It says, with reference to your show cause letter dated 30/3/2021, I'd like to inspect the documents listed on page 18 and 19 and also have a copy of the same to enable me to give a proper response. I am ready to pay the cost of the photocopy of the documents. So he asked for the documents below. and she wanted to inspect. Then page 46 is the communication issued to her. With reference to your letter mentioned in the caption, this is to inform you that as per the rule, photocopy of the document cannot be furnished to you. You may physically come to inspect the documents and take pencil note of the same. You may come on so-and-so between so-and-so PM. This was dated, my lord, 10/4/2021. Then she submitted a reply to the show cause. And the disciplinary authority being dissatisfied with the reply,
With the reply?
no, reply that has not been annexed, but I have annexed the document which shows that the disciplinary authority is dissatisfied with the reply and decided to go for an inquiry. That is annexure A4, page 47, my lord. The reply was dated 18/4/2021. Reply from now, page 47, my lord. With reference to the subject quoted in the caption, this is to inform you that we have gone through your reply to the show cause notice that was issued on 30/3/2021. However, as the reply filed by you is unsatisfactory, this is to intimate you that an inquiry into the charges is called for. A disciplinary committee has been formed and Sri so-and-so has been appointed as the presenting officer. Now, page 48 is the notice of the hearing given to her. In reference, this is dated 8/6/2021. In reference to the subject cited above, this is to intimate you that next date of preliminary hearing has been fixed on 12 June 2021 at so-and-so. You are hereby requested to attend the departmental proceeding on the given date and time. Failing which, the proceeding will be taken ex parte. Further, any communication from your end to the committee be made in official email address of the school so-and-so. This was, my lord, sent by post. Page 49 is the proof that it was sent to her by registered post. Then page 50 is the proceedings of the hearing. Members present, chairman, secretary, member, and member. In her letter dated 6/6/2021 addressed to so-and-so had asked for time. A reply dated 8/6/2021 was sent to her by registered post WhatsApp and her email stating that there will be no further adjournment and any further proceedings would proceed ex parte. On 11th of June 2021, on WhatsApp of Mr. Gobind Singh, the chairman, a message was sent from Ruth Joan stating that she will not be participating in the departmental proceeding. A reply was sent to her at 9:23 PM to her WhatsApp on 11 June 2021, stating that there will be no further adjournment and any further proceeding would proceed ex parte. The committee is of the view that the delinquent is deliberately avoiding the proceedings. In spite of being aware of the date, she having refrained from appearing, 19 June 2021 is fixed for examination of the management witness and documents. So she refused to appear in the departmental proceeding, and accordingly the committee decided that on 19 June 2021 is date fixed for explanation of the management witness and documents. This communication was also sent to her by registered post that you also will find page 51. Then the proceedings of 19 June 2021, page 52. A copy of the order sheet dated 12/6/2020 was sent to Ruth Joan Singha by speed post, school dark book, by email, WhatsApp. Ruth Joan Singha had refused to receive the letter that was sent through dark book. Today, on 19 June 2021, Sri so-and-so, the presenting officer, produced the following 5 witnesses. Number 1, Jaswanto Singh, who is a senior assistant teacher for deposition. He is marked as PW1. Sarat Kumar Singha, who is a senior assistant teacher for deposition. He is marked as PW2. Jothanglung Changsan, who is a senior assistant teacher at Moirangthem Depsing Memorial Academy, erstwhile known as Emmanuel School, Binakandi. She is marked as PW3. Rotan Singh, who is a co-founder and a parent whose children were the students of so-and-so. Jacob Surin, who is an employee of so-and-so. Ruth Joan Singha, in spite of being notified, is not present. Accordingly, as notified earlier, the disciplinary proceeding will continue ex parte. Committee has examined all the 5 witnesses. The statements of witnesses has been recorded. Accordingly, next date of the proceeding is fixed at 23rd of June 2021 at 10:30 a.m. Now, this was also sent to her by registered post that your lordship will find page 54. Now, page 55 is the proceedings of 23rd June 2021. A copy of the order sheet dated 19/6/2021 was sent to Ruth Joan Singha by speed post, school dark book, email, WhatsApp, but so-and-so had refused to receive the letter that was sent through the dark book. On 21st June 2021, so-and-so, the presenting officer, received a letter from Ruth Joan Singha, a copy of which is kept on record. The same letter was also received by the chairman, Mr. Gobind Singh, on 22nd of June 2021. The delinquent is warned not to bring unwarranted pressure on the presenting officer, and the committee, failing which, further proceedings on that ground will be initiated against her. For the answer of justice, so-and-so is asked to participate in the next date of hearing, which is fixed on so-and-so, after which no further time will be given. So she tried to create some unwanted pressure upon the presenting officer. That was recorded in this proceeding. And again, she was given opportunity to appear before the hearing on 26th of June. This was also sent to her by speed post that you also will find page 56. Then page 57, annexure A9 is the show cause notice, second show cause notice. In inviting reference to the show cause notice dated 30/3/2021, in inviting reference to the show cause notice dated 30/3/2021, an inquiry was conducted into the charges, and the inquiry committee has submitted its report on 12th July 2021. The report has been duly perused, and I conclude with the findings and conclusions of the inquiry committee against each of the charges framed against you. I agree with the findings of the inquiry committee against each of the charges. Tentatively, a major penalty is contemplated to be imposed against you. A copy of the said report is enclosed herewith, and you are required to submit your representation against the same within 10 days from the date of receipt of the same. A copy of the report is also furnished to you on your email and WhatsApp. So, inquiry report was communicated to her by this notice dated 15/7/2021. This was also sent to her by page 58, registered post, my lord, speed post. Then no reply.
So this is not the second show cause.
This is, my lord, basically, although I have termed it to be the second show cause notice, by this, my lord, she was furnished the copy of the inquiry report, and the disciplinary authority gave its tentative finding that you say whatever you want to say in the inquiry report.
Who is the inquiry report?
Inquiry report to Gathan, I know. No, the inquiry report is not enclosed here, but page 59, is the satisfaction of the disciplinary authority with the report of the inquiry committee, my lord. Whereas in terms of the approval of the managing committee, show cause notice bearing dated so and so, and whereas she so and so had given her reply on so and so, the say reply not found to be satisfactory and inquiry was directed to be held. And whereas the inquiry committee on 12th of July 2021 submitted its report, a copy there was duly forwarded to Sri Ruth Joan Singha for her comments. And whereas on expiry of the term prescribed for the submission of the comments, Ruth Joan Singha having not submitted any comments, the matter was placed before the managing committee for consideration. And whereas the managing committee, on careful consideration of the inquiry report, along with the materials available on record, was satisfied that the charges are leveled against Sri so-and-so white show cause notice that it so-and-so stood proved. Further, the managing committee concluded that Srimati so-and-so is not fit to be retained in service for the school and approved imposition of penalty of dismissal from service on her with effect from so-and-so. Accordingly, in terms of the above, you are dismissed from service with effect from 28/7/2021. This was the penalty order, my lord. This was also communicated to her, page 60 by speed post. Then this application 8/21. Document. Appeal to court. Appeal to Gatha nahi. Then she filed an appeal before the education tribunal.
Let us have a look at this route, 2007.
Yes, my lord. Tool.
Is it in this book?
Yes, my lord. A rule show cause notice edition. Assam Non-Government Educational Institutions Regulation and Management Rule 2006. Page 572 perhaps. Returnable Act. Rules. Yes.
First, you filed your appeal against your suspension.
Yes.
Yes.
Then when the suspension was pending, and when the appeal was pending.
The order of
dismissal
dismissal
order.
was
So you amended
the memo of appeal.
Yes.
Then, my lord, page 61.
This is
amended appeal. Then I just read below the prayer portion, Miller. The humble appellant, therefore, prays that your honor may be kind enough to direct the respondent to submit all the connected records as regards suspension and dismissal of the appellant, including original registers, minutes book correspondent, representations received from appellant's enquiry proceedings, magazines of the school, resolution, etc., in connection therewith as given specifically in schedule herein below before hearing the appeal. Now, schedule. Records to be submitted by the respondents. Original minute books of Emmanuel High Secondary School for the period 1987-2015, 2 books. 2015 to till date, 1 book, total 3 books to be produced by the respondent number 4. If produced, will prove all so and so, so and so, so and so, so and so. The books will also prove that Manidhan Singh was associated as teacher, and his appointment and confirmation will be reflected in 2011 and 2014, who later took over the charge of the school as so and so, which is a branch of the school. The book will also prove the confirmation of facts regarding full-time principal, post of Sri so and so, including reflection of permission resolution and authorization to deal with the official works of Binakandi school, since there was no separate registration of the school at that point of time, and further that principal Sri so and so was authorized to sign certificate. Original salary register, attendance register of Emmanuel High Secondary School for the year 1993-1997 to produce by respondent number 4. Progress report register of class KG2 of the year 1995 to be produced by the respondent number 4. Second edition of school magazine published in 2000 to be produced by the respondent number 4. All correspondences made by the appellant to the respondent number 4, as well as by the respondent number 4 to the appellant during and in the course of pendency of the present appeal during 2021, including all representations, replies, etc., submitted by the appellant in connection with the suspension as well as dismissal to be produced by the respondent number 4. All representation, appeal, correspondences made by the appellant in connection with her suspension as well as demotion and dismissal, etc., with action taken report in that connection will prove that despite filing representation, appeal, correspondence, so and so did not take any action supposed to take as per provisions of law, Assam Government Education Institution Regulation Management Act 2006 and rule frame thereunder to be produced by respondent number 2 and 3. So these were the bunch of documents which has no connection with the disciplinary proceeding initiated against her. She prayed, then the tribunal passed this order at page 65 on 15/11/2021. Both the parties are represented. Petition 80/3 pertains to appellant's prayer to call for the relevant records and documents from the respondents. Peru CR heard both learned counsel. The present appeal concerns with impugning the suspension and dismissal of the appellant by the respondent by order dated 2/1/2021, 28/7/2021 respectively. So far as direction to respondents to produce the documents as mentioned in the schedule to the petition 83 is concerned, I am of the opinion that the appellant has not tendered any cogent explanation as to why such documents pertaining to the year 1987 to 2015 are required, when prima facie it will be of no aid to the appellant vis-a-vis the alleged suspension or dismissal. No explanation is also forthcoming as to why such of whole documents sought to be called for are necessary for the purpose of this appeal, without which the adjudication of this appeal is not feasible. For the foregoing reasons, petition 80/3 is rejected. Nonetheless, call for the original records pertaining to suspension and dismissal of the appellant from the concerned respondents. Appellant shall take steps fixed on so and so for so and so. Thereafter, my lord, hearing continued and yeah. The earlier order was by Education Tribunal Kachar Silchar, Sri A.J. Bora, Miss Appeal ET 8/2021. Now, exactly asking the same documents which were rejected by the tribunal in the order dated 65, they have filed another petition that is 25/1. No? 25/1. Lordship will find page 66. Miss appeal number so and so. That the
8 of 2021.
yes, the main appeal number is 8/2021, but this petition number is 25/1. Left hand side, my lord will see there is 25/1 is written. This is against a miss petition. Again, a miss petition in the main appeal. Again, praying for documents. That the respondents, despite order to produce all original documents relating to suspension and termination, have not submitted original minutes book, 2 books of period 1987-2015, 1 book from 2015 till date, salary and attendance register for period 1993-1997, report register of class KG2 of the year 1995, school magazine published in 2000, and all original correspondences, though referred in the papers relating to the suspension and termination of the appellant. The absence of those documents which are lying in the custody of respondent number 4, the appellant be unable to prove her contention made in the appeal for the ends of justice so and so. The humble appellant therefore prays that your honor may be pleased to direct the respondent number 4 to submit original minute book, salary, attendance register, report register, KG, so and so, so and so. The previous order, page 65, the educational tribunal, after considering the prayer in the petition, recorded categorical finding that those documents are absolutely irrelevant, directed the respondent number 4 therein, that is the petitioner herein, that you produce the original records pertaining to suspension and dismissal. Now, in this petition, page 25, Miss Petition 25/1, they have dragged that particular line of the previous order, that there was a direction for submitting original documents, and added again those same documents which were prayed and rejected by the tribunal. Now, this time the tribunal has passed this impugn order, that page 67. Both sides are represented. This is dated 14/2/2023. Both sides are represented. The petition number 25/1. The petition number 25/1 filed on 25/9/2022 has been pending for orders. I have heard learned counsel for the appellant, and it is desirable to call for the record relating to suspension, dismissal of the appellant from the respondent number 4 for the purpose of disposal of the appeal. Till this, absolutely fine, no problem. Let call for the original minutes book, salary and attendance register, report register of KG2 school magazine as prayed for in the petitioner number 25, petition number 25. You know, this is absolutely wrong, my lord. This is contradictory to the previous order passed by the same tribunal. My lord, the person heading the tribunal may change, my lord, but there has to be consistency in the orders of the tribunal. So in the previous order, same very documents, the tribunal rejected that those doesn't have any relevancy. Ask the petition, respondent number 4 therein and petitioner here, that you produce the original documents concerning the departmental proceeding. Now they filed the petition, the judge, Honorable Milord presiding officer has changed. They filed a petition 25-1, same documents, and this time a different presiding officer, Milord, passed a different order. So in my humble submission, this is absolutely wrong, Milord. Till first paragraph, it is fine, no problem. We will submit whatever document is required for original document in connection with the suspension and dismissal departmental proceeding. But so far as last paragraph is concerned, Milord, this is absolutely wrong. And Lordship will kindly appreciate one thing. Last one key is in. Lordship will kindly appreciate one thing. Show cause notice was issued containing certain allegations. It contains list of documents, list of witnesses. Opportunity was given to you to inspect the list of documents. You inspected the list of documents. What were there? 20 documents were, Milord, relied on by the disciplinary authority. That these documents will be used against you to prove the charge. You inspected those documents. You submitted your reply to those documents, against those documents. That reply was rejected by the disciplinary authority, saying that no, I am not satisfied with your reply. We'll go for a regular inquiry. Milord, several dates in the regular inquiry, communications were sent to you, saying that you participate in the regular departmental proceeding or departmental inquiry. You chose not to participate. That I will not participate. You remain adamant. The departmental inquiry continued, and ultimately, having no alternative, derived conclusion on the basis of whatever material was available before the inquiry committee. So there was absolutely no wrong in deriving conclusion, number one. Number two is that you cannot say that these additional documents, what you have asked, will change the entire structure, because the disciplinary authority relied on certain documents, 20 documents. He'll have to prove basing on those documents. He cannot go beyond. So if you were so interested towards your innocence to persuade the inquiry, then you could have participated in the inquiry, asked for additional documents, placing of the additional documents. At no point of time in the entire departmental proceeding, Milord, departmental inquiry, the respondent number 4 herein, she never made any attempt to get any documents. This first miss petition 8 oblique first one miss petition 8 oblique 2021. Sorry, Milord, the first petition 80 oblique 3 and second petition 25 oblique 1 are just an afterthought to get hold of some original records which are lying in the school, because Lordship will kindly appreciate this is a sensitive issue. She has changed the entire structure of the school, Milord. The allegations, the 6-7 allegations, Lordship has seen what she has done. She had continuously signed in the name of principal. She changed the, Milord, entire structure of the school, tried to change the name of the school. Milord, land documents were altered, saying that, Milord, a wrong name was inserted. So there is something behind it which she wanted to, Milord, fulfill by asking for this document. These documents are absolutely not connected with the departmental inquiry, Milord, because she never asked for these documents during the inquiry. Had those documents would have been so relevant for inquiry, she would have asked. And if you can make out a case that the departmental inquiry committee relied on these particular documents which you have asked during the course of the inquiry, then it will be a different case altogether. Then you can urge before the tribunal saying that, look, the disciplinary authority or the departmental inquiry committee went beyond the charges. they went beyond the documents enclosed in the charge sheet and derived conclusion. So nothing sort of such aspects were ever my lord, produced or ever raised during the entire inquiry, my lord. So in my humble submission, my lord, this order of the tribunal, that page 67, annexure A14 collie, last paragraph, no? Ekon ki ho? Is absolutely, my lord, absolutely contradictory and perverse. And there is a notice given to us, page 68, giving the list of documents which were to be produced. So we, having been able to make out a prima facie case before your lordships, this honorable court was pleased to stay. Pleased to stay this notice and the impugn order, that is 4/2/2023. So it just to change only. Exactly. So this is Lordship will kindly appreciate that page 65 order was passed on 15/11/2021, by which her prayer in the petition 80/3 was rejected. This is dated 15/11/2021. And thereafter, she waited till April 25/9. Sorry, my lord, she waited till September. Almost a year. That your lordship will find page 67. Petition number 25/1 was filed on 25/9/2022. So this is replica of the my lord, intention of the respondent number 4, which she fructified in the allegations contained in the charge sheet. In the charge sheet also, lordship will find such kind of allegations taking chance. Here also, my lord, see 15/11/2021, her petition was rejected. Again, asking same prayer after 1 year, when the presiding officer changed, an attempt was made to get the documents. And this time, my lord, the court below, in clear non-application of mine, in a mechanical manner, in my respectful submission, my lord, with all due respect, passed this order overlooking the previous order passed by the honorable tribunal. So in my humble submission, this is absolutely perverse and contradictory. So far as first paragraph, till first paragraph is concerned, we don't have any objection. We will produce whatever the documents, original documents with regard to departmental proceeding and suspension. No problem in that. But last part, my lord, we have problem.
Including the documents relied by.
Yes, yes. The list of documents, whatever, because those list of documents, 20 documents, she has already inspected. We will again produce, because in the records, those documents will form part of the charge sheet. It will be part of the charge sheet in our records. So those documents will produce. But these documents, my lord, will not be able to produce, my lord. And this is absolutely unconnected to the departmental proceeding. My lord, 1987, my lord, what is this? You need 1987, minute book of 1987, 15. I don't know whether she was born or not. So that is precisely my case, my lord. The learned tribunal absolutely acted in absolute, my lord, contradiction. Progress report of KG class 2, my lord. Absolutely. Those are not connected at all, my lord. In my humble submission, my lord. First paragraph, we are okay. Last paragraph, my lord, there will be difficulty. The reason is that those documents are not at all relevant for the proceeding or for a proper hearing by the learned tribunal into the matter pertaining to the departmental proceeding. That is my precise submission. Much obliged, my lord. I'll reserve my right to reply against the whatever he says, my friends.
May it please. My lord, initial 20 minutes of my learned friend's argument is based on disciplinary proceeding. My humble response to this would be, in the garb of narrating the checkered history of the case, my learned friend in this writ proceeding has attempted to assert the allegations which are subjudiced. My learned friend has made statement to the extent that respondent number 4 has resorted to this, has resorted to that. How come these statements can be entertained by this honorable court exercising the jurisdiction? And these are the statements which have been made in major part of their petition as well. Meaning thereby that the intention is to create a ground where an adjudication is already, my lord, here the attempt that I can make out is that by narrating these facts, the assertion that is sought to be made before this honorable court is that respondent number 4 is guilty. That is subject to adjudication before the learned educational tribunal. This is my response to the attempt made by my learned friend to narrate these facts. Nonetheless, these facts are there. These are not denied. But the fact remains is this writ petition basically starts from page 61. Before that, the entire history of the case, that is not something that is very relevant in the context of this particular proceeding. This particular proceeding basically starts from page 61, where we had filed one petition seeking for certain documents. The documents were in the nature as narrated in the schedule. We had mentioned about the relevance of those documents. However, unfortunately, at page 65, that by order dated 15/11/2021, at that point of time, the Learned Educational Tribunal had passed an order rejecting our prayer insofar as calling for those documents are concerned, by saying that no explanation was provided as to how those documents are relevant. Nonetheless, in the same order, there was a direction upon the petitioner herein, who is the respondent in the appeal, saying nonetheless call for the original records pertaining to submission and dismissal of the appellant from the concerned respondents. And the next date was fixed on 23/12/2021. Now here, my lord, one thing that has been pointed out by my learned friend is that thereafter I waited till September 2022 and then filed this petition numbered as 25/1, which goes on to show the afterthought. Now to this I have responded in my affidavit in opposition, where I have in fact, this is one aspect which rather goes against her, being the petitioner. There was a direction, wide order dated 15/11/2021, down below, calling for the original records pertaining to suspension and dismissal of the appellant from the concerned respondent, that is the petitioner hearing. Now, thereafter, my lord,
on 23/12/2021, 25/2/2022, 25/4/2022, 11/7/2022, 5/9/2022, 9/11/2022, 4/1/2023, 14/2/2023, and 30/3/2023. Adjournments were taken by the petition before the educational tribunal, where the initial direction for production of original documents were not complied with. Adjournments were sought for date after date without giving any satisfactory explanation as to why they were not even able to produce the documents relevant for the adjudication of the appeal in connection with suspension that was directed to them to be produced. Now, after a lapse of more than a year, we file a petition again. And here, as I have stated earlier, we streamlined our requirement. Now, this is, my lord will appreciate one thing. This is an appeal before the educational tribunal against the order of dismissal. Initially, it was the order of suspension. Subsequently, it was the order of dismissal. Now, in an appeal filed by me, I have procedurally, my lord, every right to point out documents which I want to rely upon and which is not in my custody, which categorically I make a submission that these documents are in the custody of the respondent. That means the petitioner hearing, they being the authority of the school, she being the authority of the school, being the principal, and also the secretary of the school. These documents are in her custody, and I, to establish my case in the appeal, pray for calling for those documents. Now, eventually the order that gets passed in my favor, against that, they have come on various grounds, one which apparently now seems to be change of chair in the educational tribunal. It is not pleaded in the writ petition. This is an argument that has been now taken up, that there is a change in chair or the personnel sitting on the chair, because of which this order has got passed. Extremely serious allegation, my lord. I reserve my comments on that, because this is directly pinpointing to the integrity of the person who has passed the order.
No.
Number one. Number two,
Submission.
number two,
Kindly don't twist.
number two, Malak, this is what has been submitted. That is what I am saying, that earlier there was one judge, subsequently there is a subsequent judge who has passed the order, therefore the order has
That
changed.
was never my submission. My submission was that, my lord, they have taken a chance after the change of the presiding officer. I never pinpointed any allegation against the presiding officer, my lord.
My lord,
I never.
Impliedly, that is my understanding. If
That
is not
understanding is
so,
wrong.
If that is wrong, then that's fine. But that is my understanding. Nonetheless, my lord, secondly, insofar as the order that was subsequently passed, now, does the order passed earlier, that is on 15/11/2021, preclude the educational tribunal subsequently from passing the order, thereby directing for calling of the records? Is there any bar under the principle of res judicata where an educational tribunal, having earlier passed an order where my petition for calling of certain documents was rejected, cannot subsequently pass an order entertaining my petition for calling of those documents where I am saying repeatedly that these documents are relevant for the purpose of adjudicating my appeal? This is my appeal, my lord. This is my appeal that I have filed, and I want to establish my appeal by relying upon these documents. Now, here, my lord, insofar as the contention of the petitioner that these documents are not relevant for the purpose of adjudication of the appeal is concerned. Now, to that effect, my lord, there is a procedure, and this procedure is laid down under the Code of Civil Procedure, which in essence is followed by the educational tribunal in adjudicating matters. Now, Order 11, Rule 14 may kindly be looked into, my lord. Order 11, Rule 14 of the Code of Civil Procedure may kindly be looked into. CPC? CPC. এটুকু হয়ে যাব এটুকু Order 11, Rule 14, my lord. My lord has got Order 11, Rule 14. Yeah. Production of documents. it shall be lawful for the court at any time during the pendency of any suit to order the production by any party thereto upon oath of such of the documents in his possession or power relating to any matter in question in such suit as the court shall think right, and the court may deal with such documents when produced in such manner as shall appear just. Now, here is a provision, my lord, where it clearly lays down that the court, which in this case is the tribunal, has the right at any stage during the pendency of the proceeding to call for documents which are in the custody of the person. In this case, it is in the custody of the school authority, which is the principal, which is the petitioner herein. So the court has got the prerogative, the right to call for document at any stage of the proceeding, and thereafter the court will look into it. Now, insofar as relevancy of the said document is concerned, to that also, my lord, there is a law prescribed. Now, if your lordship kindly takes up the provision of Order 13, Rule 3. Order 13, Rule 3. Your lordship has got Order 13, Rule 3, my lord.
Yeah.
Rejection of irrelevant or inadmissible documents. The court may, at any stage of the suit, reject any document which it considers irrelevant or otherwise inadmissible, recording the grounds of such rejection. So this provision is subsequent to the provision under Order 11, Rule 14. First, my lord, the documents which are called for, having said that these documents are in the custody of the other side, needs to be produced. The court needs to peruse those documents, and thereafter, if those documents are found to be irrelevant and inadmissible, those documents can be rejected. Now, my learned friend has already, on behalf of the petitioner, stated that they won't be able to produce those documents. Now, whether on oath they can come up and say that those documents are not within their custody, in my humble submission, no. Only thing that they are pointing out is relevancy or inadmissibility or non-connection of those documents in the context of the appeal. How are they to decide? Who are they to decide that whether those documents are relevant or admissible in the context of my appeal that I have filed? That has to be decided by the Learned Educational Tribunal only when those documents are before the Learned Educational Tribunal, not before that. And to that effect, there is a procedure prescribed. This procedure has to be followed. Now, my humble contention is that the desperation that is being shown by the petitioner in coming up against an order where the compliance of which would not have prejudiced them, because they could have been able to satisfy the Learned Educational Tribunal that these documents, see, we have produced these documents are not relevant for the purpose of adjudication of this appeal. So therefore, these documents should be outrightly rejected. These documents need not be admitted insofar as the adjudication of the appeal is concerned. They have not done that, my lord. What they have done is straight away against that order that they have come up before this honorable court, against the order whereby the direction has been given to them to produce those documents. Now, my respectful submission is whether the honorable court also, in exercise of jurisdiction under Article 226, will this honorable court also be in a position to decide whether these documents are relevant or irrelevant for the purpose of adjudicating my appeal? My humble answer would be perhaps no. So that has to be decided only after perusal of those documents. And that opportunity is what respondent number 4 is trying to be deprived of. That is the attempt that is being made. And my lord, one submission, my learned friend has made various submissions. One small appraisal of fact that I may perhaps do, which perhaps is not relevant in the context of the case, is this is a case between mother and daughter, where the principal is the mother and respondent number 4, who is at the receiving end, is the daughter. And your lordship will remember, your lordship in this honorable court has also been adjudicating. There are several other litigations which are pending in connection with this particular school, and in which these my lord, litigants are the parties in those cases as well. So when my learned friend says that there is something behind, even I agree to him. There are many things behind. But for that, my lord, these things, my lord, in my respectful submission, should not be resorted to. If there is a legal battle that has been denounced and that is continuing between a mother and a daughter, and they are so desperate to continue with the litigation, let there be fair opportunity to all. Why should one party have the upper hand and the other be at the receiving end, where the daughter is even not allowed to call for documents which she wants to rely for adjudication of the appeal? And my lord, against the suspension order, it is not that we had gone to the educational tribunal straight away. We had come before this honorable court initially. After coming to before this honorable court, on being pointed out and rightly being pointed out by the principal of the school, was represented by some other counsel at that point of time, this honorable court had relegated us to the educational tribunal. After which we filed the appeal against the suspension order. During the pendency of the appeal, order of dismissal was passed. Although we had filed petition that there should not be any subsequent order passed in this particular on this particular issue on the principle of least pendens. Nonetheless, that order was passed. We preferred amended memo of appeal that was allowed on objection. That was also objected to, but subsequently that was allowed. Our amendment, the prayer for amendment was allowed by the educational tribunal, and now our case is against the order of suspension as well as the subsequent order of dismissal. Now, to reach a fair adjudication, now to render a fair adjudication, if I am not allowed to even ask for calling of documents which I want to rely upon to establish my case, my lord, this will be extremely prejudicial and it will cause extreme hardship to me. And the reasons that they are coming up with for not producing these documents. Now, this also does not inspire confidence, because this itself goes to show that there are elements in those documents which perhaps will be in my favor if they are perused and if they are looked into. If they are not found to be relevant, if they are not found to be if they are not found to be admissible, fine, that will be rejected eventually, but under due course of law, not in the manner in which it is thought to be done by the petitioner. That the documents were eventually not called for, rejected. Subsequently, those were called for. So therefore, that order is bad in law. This is perhaps not the right way of going about it, my lord. So in my respectful submission, and this matter, my lord, the matter before the educational tribunal, that has also, although there is the interim order that has been passed by this honorable court, is not staying the proceeding of the appeal. But your lordship will kindly appreciate the fact that without being able to produce, without being able to ask for those documents which I am relying upon in the appeal, my appeal is all as good as my lord, this present situation that has arisen because of not being able to call for the documents. It's as good as dismissal of my appeal, because I am already non-suited. If I am not able to rely, if I am not able to get a fair chance to place my case, there is no point in pursuing the appeal any further. So as good as this order has, my lord, this interference with this order will be as good as non-suiting me at the very threshold. So my respectful submission, my lord, would be that the order dated 14/2/2023 does not deserve any interference from this honorable court. The order rather deserves compliance by the respondent in the appeal, the petitioner herein before this honorable court. And thereafter, my lord, whatever eventually the honorable, the learned tribunal, the educational tribunal decides as regards relevancy or admissibility of those documents, there they can very well challenge thereafter. If they are not satisfied with the order to be passed thereafter by the learned educational tribunal, they can thereafter very well challenge it. They will assail it before this honorable court again, but not at this stage. This is not the stage where even the very issue of admissibility and relevancy is yet to be decided. This is not the way to, my lord, cut my lease. That is my respectful submission. And my humble prayer is that this writ petition at this stage perhaps is not deserving of being entertained, and I pray that this matter may, this writ petition may be dismissed with the direction to the educational tribunal to take up this matter post 14/2/2023, the direction that was given for production of the documents. But this is my humble submission.
Well, the first submission that was made by my learned brother is that by reading the show cause notice and other documents, I tried to make an assertion that respondent number 4 is guilty. My lord, in my respectful submission, there was a show cause, there was a reply, there was a departmental inquiry. And after that inquiry, it is a fact that it's not my assertion. She was found guilty in a departmental inquiry, my lord. So in my submission, my lord, I never asserted. It was proof. The allegations were proved in a departmental inquiry wherein you refused to participate despite repeated notice, and the charges were proved, and thereafter you were found guilty and penalty was imposed. Now, second contention is that by referring to Order 11, Rule 14 of CPC, that is regarding production of document, the respondent submitted that court has the right at any stage of the proceeding to call for documents, my lord. There is no dispute with regard to this proposition, my lord. But here the court itself, page 65, rejected your prayer. Court itself rejected your prayer. We are saying that the subsequent order, which was passed overlooking the previous order, is wrong. So this argument relying on Order 11, Rule 14 CPC is absolutely, my lord, unsustainable. Then another submission was made with regard to Order 13, Rule 3, rejection of inadmissible and irrelevant document. Court can reject after perusal of the document by the court. Now, my submission is same, that the court has rejected your prayer. Then why the second order allowing? So we are not impugning this page 65. We are impugning page 67. So this submission also, that my lord, court can reject after perusal of the document by the court, is unsustainable. Then my lord, they haven't challenged the page 65 order. Basically, the educational tribunal rejected their prayer in page 65. There was no challenge. So without making any challenge to that, you cannot question that order. Now, a submission has been made short while ago before your lordships that whether this court will examine relevancy. My lord, time and again your lordships deal with departmental proceeding matters, my lord. Matters wherein penalty of dismissal from service is imposed. Your lordship also wants to inspect records. What records your lordships call for? The records of the departmental proceeding. Your lordships does not call for records that bring your land documents, bring your birth certificate, bring your ration card to decide a departmental proceeding matter. So herein, that is what is happening. Even the learned tribunal also cannot, because this law is absolutely well settled. In a department, when a departmental proceeding is challenged in a court or a tribunal, it's the decision-making process, which is, my lord, judicially reviewed. The decision is not reviewed. If there is any flaw, that the tribunal will consider in the procedure prescribed. But the tribunal will not step into the shoes of the disciplinary authority as an appellate authority to come to a different conclusion. Now, even assuming these documents are produced, can the tribunal come to a different conclusion relying on these documents, my lord? I am asking myself. So, assuming the documents which the respondent number 4 is asking is produced before learned tribunal, can the learned tribunal go beyond the records of the DP, my lord, to come to a different finding that yes, these documents have come? Those documents were not part of form of the departmental proceeding. She never asked for production of those documents during the course of the inquiry. Can the tribunal come to a different conclusion with regard to the penalty imposed, relying on those documents, my lord? In my respectful submission, that will be per se illegal, my lord. That is, my lord, beyond any scope. So in my humble submission, so when the learned tribunal cannot go into those documents to decide the merit of the DP, then where is the question of asking for production of those documents? That's why in the first order, the learned tribunal has rejected and very correctly said that you produce the departmental proceeding records and rest are rejected. Now, in my humble submission, Miller, this second order is hit by the section 11 of CPC, Miller, res judicata. If I just read section 11, no court shall try any suit or issue in which the matter directly or substantially in issue has been directly and substantially in issue in a formal suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court or in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised or has been heard and finally decided by such court. So in my humble submission, once an issue that was before the tribunal by virtue of the first petition that was decided, you cannot file a subsequent petition and ask for a different order. The tribunal could not have gone past the second order. So this is precisely my submission, Milord. This page 68 order is absolutely erroneous, Milord. It incurs interference of this honorable court, the second part of the order. And I pray that the writ petition be, Milord, allowed by setting aside and quashing this 14/2/2023 order of the tribunal, Milord. This is my precise submission, Milord.
Well, just on a law point, section 11 that my learned friend referred to, section 11 is in the context of two different suits, two different litigations. It is not within the same suit or within the same litigation. So that clarification is there in the explanation itself in the section 11 itself. Explanation 1 itself provides the expression former suit shall denote a suit which has been decided prior to the suit in question. So that answers my learned friend's question.
This is my own principle, Milord, I have submitted.
That's. You're done?
I'm going to recommend number 123.
Do you have anything to say?
Actually, we have no, because these are the private institutions. Moreover, regarding the document, and it is already pending. This matter is already pending and sub judice matter.
Oh, so that is a. That's something else. Okay. So it's what. And each of our.
Respond number 4.
Much obliged, deeply obliged.